mentioned about contempt application. On 19th November 2024. 19th November 2024.
24? Okay. Second January.
Your Lordship may be permitted.
Content application.
Your Lordship may be permitted to mention an original side matter for extension of interim order which is expiring today, Your Lordship.
Why you are mentioning today?
Your Lordship, the interim order is going to expire today only, Your Lordship.
So why you are mentioning today? Why you have not mentioned yesterday?
Your Lordship, we even tried mentioning, but Your Lordship,
Huh?
Your Lordship, we tried mentioning it on Monday, but Your Lordship has not said to wait for the list to collapse so that the matter is taken up.
List is there. It is in the list.
Yes, Your Lordship. It's item number
Today is in
39.
the list.
Yes, Your Lordship.
Item number?
39, Your Lordship.
All right, wait. Come at 2 o'clock upon notice to other side.
Your Lordship, that has been served.
Come at 2 o'clock.
But may I be permitted to
Then you
mention?
should have mentioned yesterday or very well. Chalo,
May I be permitted to mention an original side matter, my lord? This is chapter 37 suit, my lord.
it's not
It's
mentioning. No, don't mention today.
I'll mention
Next.
to
Your Lordship may be pleased to grant a modification for application for your
I
order.
can't hear you.
Your Lordship may be pleased to grant a modification of the order dated 3/11/2024, 3rd November of your Lordship's order, my Lord. This is a specially assigned matter, my Lord. Please, sir.
Specially assigned matter for modification.
For modification of your Lordship's order of 3rd November.
It will appear after some time.
Your Lordship, we will face contempt if the modification is not made. The petitioner have also filed for modification of your. The petitioner have also applied for the filed an application for the modification of your Lordship's order yesterday.
Appellate side.
Yes, your Lordship.
It's in the list.
No, your Lordship.
কেন অ্যাসাইন্ড হলে তো লিস্টে হবে
My lord, actually, my lord, the matter was specially assigned when the Justice Basu is not here, my lord. And the reason,
so when justice so mention before him
my lord, your lordship
your
order,
lordship.
so what
that order has not been modified by Justice Basu, my lord. The order, your lordship passed an order for publish the result of the student, my lord, upon the university, my lord. According to rules, my lord, on the last question, that is my mistake, my lord. According to rules, the college should pass the release, publish the result, my lord. That is the problem, my lord. But
so today I don't have the determination. It's an assigned matter. Unless it is again assigned, I cannot. The application.
Modification only, my lord.
Just modification.
Modification of
Your
an
lordship.
order which is not within my jurisdiction now. It was an assigned for 15 days when I passed the order.
But your lordship order,
Sir, I will not do it. You take appropriate step. Have you mentioned before his lordship then? You submit before his lordship that it was during that 15 days it was passed. So again, then he has to be assigned. Otherwise, how can I?
Your Lordship, may I be permitted to mention a matter for inclusion? It's a contempt matter. Your Lordship, order was passed on 19th of June, 2025. Your Lordship, the matter is urgent because he's a retired BSF employee. Your Lordship had directed the authorities to take hearing, pass a reasoned order. They have
So where is the urgency? Retired employee will face.
he has not received his retired benefits, Lordship.
No urgency.
And he's a handicapped person. He is
January 2.
grateful, Lordship.
2nd January,
Grateful, Lordship.
content happening.
Sir, may I mention one matter? May I mention one matter? My lord, for the correction order or judgment dated 3/11/2025 in Devdeep Singh matter, my lord.
Justice Basu's determination.
Yes, my lord.
I will not touch. Go and mention before him.
My lord,
Next.
the urgency is.
I don't have. I have no determination. Sorry, no. Next. Yes. Take the microphone.
I am appearing on behalf of Mr. Najimul Hussain. Personal difficulties, he left the court, my lord. I am paying for note today, my lord.
Passed over for the day.
No, I am also petitioner.
Next.
I have no objection.
Please, your lordship.
Next.
My lord, I would be seeking an adjournment for 1 week. The pension in this matter has been approved. We have just received it. It's not been paid yet, but it's been approved. The only
Passed
thing-
over for the day. Next.
That has also been already been issued, my lord. Nothing late.
No. Areas has not been paid.
That is
1 week.
Arey, come on the next day. We'll see. Passed over for the day. Next. 3 দেখি কাগজ দেখি ফার্স্ট ডে combined monthly list of November 2025 তো ঠিকই আছে আসুন none appears for the petitioner nor any accommodation has been sought for. Paragraph. The last order dated June 13, 2025 speaks for itself. Paragraph. In view of the above, comma, the matter shall appear under the heading content application on February 27, 2026. Chalo, next. দেখি কাগজ দেখি আসুন Paragraph. The last order dated August 25, 2025 speaks for itself. তার উপরে মাথায় none appears for the petitioner nor any accommodation has been sought for. In view of the above paragraph, the matter shall appear under the heading content application on February 27, 2022. 6. Paragraph. On that day, if the content application is not pressed, the proceeding may be dropped. আচ্ছা আর আগেরটা তো তাই লিখে দিন যেটা none appears for the petitioner. On the next day করে দিন. On that day না করে on next day. On the next day, if the content application is not pressed, the same may be dropped. Next.
Lord, I pray for a short passover in item number 4.
5.
4.
4, I have passed an order.
But item
Next.
number 5, my lord, I am for the petition. I am for the petition.
Yes. First time.
No, my lord. On the last occasion, your lordship order, my lord, they deposited the amount that matter of compensation. Now, my lord, once the report from the Registrar General as to whether that has been invested in any
Whether that has been
invested in which account and whether the amount has been actually deposited or not.
Very well. Now what to do? To release the amount.
So, my lord, your lordship on the last occasion,
Take the microphone.
your lordship in your lordship's order indicated, then I have to, if your lordship kindly come, your lordship's order.
Time to deposit such checks and extended till such and such. Registered general shall deposit if the check is deposited within the extended year time.
My lord, page 80 of my contempt application,
The matter shall appear. Page 80.
page 80, and ultimately 81 is a directions of your lordship.
Yes.
A, B, C.
Has this traveled up to Supreme Court? The division bench affirmed, that's all.
Yes. That both the order of your lordships and the division bench is reported.
This is reported though. Yes, you have given me
Your
that.
lordship's order is reported, division bench order is also reported. My lord, now we have to do the, my lord, direction of E, 81.
81E.
81, page 81 E. We have to now.
Very well. So the Registrar General shall take steps in terms of E and F. So previous amount is also lying, this amount is also lying.
My lord, previous
5
amount,
plus 5.
my lord, previous amount is whether lying or not. My lord, they have only intimated with a letter to me that we have already deposited. But actually it has been whether deposited or not. That's why your lordship asks a report from the Registrar General. And which date it was deposited, in which account it was, and what interest is.
Show me the order of Registrar General to deposit time to deposit such checks and this.
My lord, kindly consider your lordship last order.
Yes, that is only with regard to 5 lakh.
No, my lord, at the penultimate paragraph of your lordship in the last order.
Date.
Last order, dated.
25th August.
Yes, yes. At the last, your lordship
Registrar
directed.
General shall file a report
Yes.
with regard to the entire deposit.
Yes, my lord.
No, that was the direction for entire deposit, not the part deposit.
So 5 plus 5.
5 plus.
That's right.
My lord, we have, my lord, deposited and the affidavit of compliance is there.
Ashun. The order dated August 25, 2025 speaks for itself. Paragraph. The report of the learned Registrar General dated September 26, 2025 placed before this court shows that a sum of rupees 5 lakh has been deposited by, you are appearing for?
The DPSC Purvo Bardhaman, the
Alleged
contemner number
contemner.
1, sole contemner.
Volunteer number 1,
Only sole contemner.
Sole
there.
contemner.
sole contemner.
Prior to filing.
Oh,
we
it
have,
was
my lord,
paid,
yes.
paid. Oh, then the question of 10.
It was paid, but only later it is intimated to that has been deposited to the Registrar General.
General report দিয়েছে.
1 second. Sole contemner because who has not paid
Paid.
5 lakhs. So
Before
it's a
filing.
case of 5 lakhs now. The balance previous 5 lakhs has already been paid.
পেয়েছিস নাকি? Well, that has
2 sets of 5 lakhs. 1 set paid.
I'll deposited to Registrar General, not paid.
This is this one.
My lord.
What is the other 5 lakh?
My lord, that is, my lord, if your lordship kindly come to last annexure of my contempt application, by it later dated, the learned advocate intimated that they have deposited before the learned Registrar General.
So both of them have deposited.
Yes, that is the direction of your lordship.
Achha, so it is lying before the
Registrar General,
and this is a new deposit.
new deposit by
Second 5 deposit. All right. So how many contemners?
my lord, now only one contempt.
Oh, because one has already
Already
deposited. So he was not in the contempt. All right.
After the division bench order, first contemner, my lord, deposited. He has not made party. Second one.
Naturally. Ashun. কি বললাম? Sole contemner in terms of the order dated August 25, 2025. In terms of the contemner herein. Sole lekha dokhane contemner herein.
But kindly give the date also.
And the same has been, please, and the same has been invested by the Registrar General. The amount was deposited on August 27, 2025. Paragraph. Today, Mr. I forgot it says. Soibal Acharya. Take the microphone. Take the microphone. Today, Mr. Soibal Acharya, Learned Counsel, appearing for the contemner, has filed an affidavit of compliance, the same is taken on record. The money receipt appended date, the money receipt dated August 27, 2025, appended thereto shows that the sum of rupees 5 lakh has already been deposited with the office of the Registrar General, Learned Registrar General. Poster. In view of the above, the largest Learned Registrar General shall now disburse the amount to the two petitioners.
But amount of 10 lakhs, my lord, kindly specify.
Oh, তাহলে ওটা বলতে হবে। দাঁড়ান, হয়ে গেল? In view of the above কেটে দিন।
10 lakh along with interest.
সেটা রেজিস্টার ইনভেস্ট করবে।
Next.
এটা কি আবার করেছিস কেন? হ্যাঁ।
Another principal sum of 5 lakh had already been deposited by the respondent number in the writ petition.
Respondent number
In the writ
10.
petition.
10.
By the respondent number 10 in the writ petition, which is also lying with the Learned Registrar General of this court. As this court has been informed by the Learned Counsel for the parties.
My lord, it appendix, my lord, page 98. 98 of my contempt application, paragraph number 2. Paragraph number 2.
What does it say? Letter.
Well, letter. A check number is also there, 5 lakh. And date of deposit is also.
কি বললাম? As would be evident from the letter of the Learned Advocate dated, letter of the Learned Advocate for the respondent number 10 in the writ petition, dated December 23, 2024, annexure D at page 97 to the writ petition, to the content application. Paragraph. Therefore, today, the principal sum of rupees 10 lakhs are lying under the custody of in the custody of the Learned Registrar General, having been invested in the fixed deposit account. Paragraph. It appears to on perusal of the materials on record that a total sum of rupees 10 lakhs is now lying deposited under the custody of the learned Registrar General of this court. Pursuant to the judgment of this court dated February 6, 2024, affirmed by the Honorable Division Bench by its judgment dated
Judgment dated 14/11/2020.
November 14, 2024. Question. In view of the above, the learned Registrar General now shall disburse the amount in favor of the petitioners following the direction made in paragraph 33 and the subparagraphs they are under of the
43, my lord.
paragraph 43, sorry, paragraph 43 ta bold and the subparagraphs they are under. Eta puro bold hobe. They are under of the judgment of this court dated
February 6.
February 6, 2024. Paragraph. The entire exercise shall be carried out and completed by the learned Registrar General within 4 weeks from the date of communication of this order. Paragraph. It is made clear that the petitioners and the learned advocate on record for the petitioners shall cooperate the learned Registrar General in every manner whenever they shall be requested to do so. Paragraph. Nothing further survives in this content proceeding. Paragraph. Accordingly, bold. Ruleful kichu hoyni. CPAN bold 218 of 2025 stands dropped and closed. Drop bold, close bold. Paragraph. The application CPAN bold 218 of 2025 stands disposed of. Thank you. I'm so sorry, Mr. Acharya.
My lord, only one.
No, my lord, only thing I am grateful to your lordship, my lord, this judgment of your lordship, my lord, helps in another matter. I am throwing placing the division bench also.
My
But yes, the writ court has
But the
allowed.
amount is lesser.
That's the
That's
reason.
different issue.
Why? You tell me. Why can I tell you now?
I understand, well, but this judgment helps me a lot.
On principle of law. On principle of law. বন্ধ করো।
lordships also in your lordship's order indicate along with interest, if any.
Sir, that direction is there. That's why I
Paragraph
quoted.
43 is
40.
clear.
Yes.
43 is there.
Grateful, man. Grateful.
Deeply obliged.
Thank you so much. At least the point of law has been settled
Yes.
through my judgment that the damages can be levied by the writ court.
Prior to that, my lord, it was the observation of this honorable court. If you lost something, you prefer before the appropriate forum. This is, my lord, that is why this judgment helps a lot.
Yes,
My lord, well, I am the petitioner. Well, here the my lord direction was passed by your lordship upon the land acquisition collector to give the certain document which I have preferred by way of Information Act, Right to Information Act.
let me see my order.
Yes, my lord, kindly see page number 33. They have complied it, but after a lapse of 4 months,
Oh, so for that content,
yes, it should be because
file a
the
suit
land-
for damage.
but damage, no, my lord, under the contempt.
Show me. Yes, show me.
Your lordship know enough experience, my lord, by the protection and the
Show me.
majesty of the judiciary.
Come on, show me the order from content application.
Yes, kindly see page 33.
Yes.
Damage, my lord, I can, but lordship has enough power because your lordship's order were violated willfully and, my lord,
Ashu. This is an order, this is a content proceeding. Now, তার আগে Mr. Shomiron Giri, learned advocate, appears for the petitioner.
my lord, affidavit filed. So it
Yes,
will be hard.
I will record that.
It will be hard, my lord, on
Mr.
merit.
Soumitra Bandyopadhyay, learned advocate, appears for the alleged contemner. How many?
Along with Mr. Priyabrata.
How many contemner?
My beef is not it, he's coming.
No. Contemner, contemner number 4.
They are not unnecessary.
1, 2, 4. They are already.
Tell me, you are appearing for whom?
All the respondent, my lord.
Contemners.
Contemners, yes.
Full stop.
All the contemners.
This content proceeding has arisen from an order dated November 13, 2024. Under the direction of the court, the alleged contemnants, the respondent number 7 in the writ petition, / contemners were directed respondent number 7 in the writ petition was directed to provide certain information to the petitioner in terms of its application submitted with relevant records and documents within a period of 4 weeks from the date of communication of the order. Full stop. The order is available at page
33, my lord.
29, Annexure P2 at page 29 to the writ petition, to the content application. Where is your compliance report, sir?
My lord, compliance report, my lord, I have filed my affidavit in reply. Page number
Where is
30.
your compliance report?
We have filed one of the last suggestion.
Full stop. The alleged contemners have filed compliance report. Dated
18th July 2025, my lord, this is upon, my lord.
by way of an affidavit. Compliance report by way of an affidavit.
It has been filed on, my lord, 25th of August.
Show me. No.
After filing the contempt application.
আরে ওকে দেখি কি হবে, তুমি দেখো না কমপ্লায়েন্স রিপোর্টটা কোথায়। ঠিক আছে, দাও। Compliance report by way of an affidavit affirmed on July 18, 2025. Full stop. The compliance report shows that the direction of this court has been complied with. Paragraph. However, the petitioner had opposed the compliance report and filed its affidavit in opposition thereto, which was affirmed on July 29, 2025. First, on perusal of the affidavit in opposition, it appears to this court that, the petitioner's complaint is that the materials were not furnished to the petitioner within the time of 4 weeks mentioned in the order and much later than that.
While I have filed the contempt application after that.
Much later than that, and more precisely and more specifically after filing of the contempt application. Full stop. Paragraph. Mr. Shomiran Giri, learned counsel appearing for the petitioner, submits this itself is an act of contempt. Paragraph. After considering the submissions made on behalf of the petitioner and on perusal of the reports, on perusal of the records, this court is of the considered view that as the direction of this court has already been complied with substantially, even if not within the time specified in the order, but the material compliance is there, considering the punishment in a contempt proceeding, which is grave in nature, this court finds there is no further requirement to proceed with this contempt proceeding. Full stop. Paragraph. Nothing further survives in this contempt proceeding. Paragraph. Accordingly, CPAN 268 of 2025 stands dropped and closed. Paragraph. The application CPAN is bold, 268 of 2025 stands disposed of.
My submission, my lord, according to Supreme Court judgment, within the time it should be for protect the dignity and no. My claim will not go there. Because the Supreme Court says, that is why I am submitting.
Testy. Next.
Then, my lord, the contempt act should be abolished.
And that up to, you better suggest it to the legislature.
So how is it possible?
Referring to this matter, that for this reason, this order has been passed, so contempt act should be abolished.
No, that is...
All right, next.
My lord, I appear for the petitioner. An application which was taken out, and this your lordship was pleased to pass.
Complied or not?
Not complied. That is the difficulty. Not complied.
Let me see my order.
Your last order is 8-8.
No. First, my order in contempt,
Yes.
sir.
Your order in
Out of which contempt arose?
Yes.
5th of November?
Yes, 5th of November. আমাদের application টা বড় করুনি কেন?
Freezing order has not been communicated.
Everything has been communicated. They have given a report.
Reasoned order has been communicated. Reasoned order has gone in your favor.
Yes, kindly
Acha.
see.
So let us come to 119. Mr. De. 119. Read the portion. Operative part. Direction.
There is no reason order.
119, sir. দেখুন ছোট্ট লিখে রাখো বসে বসে Mr. Shivoprasad Mukherjee, a senior advocate, appears for the petitioner. How many containers?
What?
Mr. Chondi Charan De, learned advocate, appears for the container. Yes, sir. Show me, sir. 119.
5/11 ডেটে হচ্ছে অর্ডারটা পেজ নাম্বার 119
119. And you take this microphone, Mr. Mukherjee. This one. Yes.
119 is the order passed by your lordship.
Out of which contempt arose?
Yes, madam.
Kindly read the direction. In view of the above.
In view of the above, the respondent number 4 who has concluded the hearing is directed to communicate the reasoned order to the petitioners positively within a period of 4 weeks from the date of communication of this order.
Pause here for a moment.
Yes, madam.
Communicated?
Yes.
Very well. Next.
In the event the reasoned order goes in favor of the petitioners, all necessary and consequential steps shall be taken by the respondent number 4 or any other appropriate authority positively within a further period of 4 weeks from the date of the said reasoned order upon compliance of all necessary formalities in accordance with law.
Next. Tell me what was the nature of the reasoned order?
Kindly see the nature of the reasoned order was the respondent number 4 was directed to have a
page.
This is this page, my lord, 119. For which
reasoned order. They have communicated. Compliance report.
My lord.
না এটা না এটা পরে
Come to page 5.
Page 5.
Yes, compliance report, order sheet.
120 page 5
3rd July, Mr. Chondi Charan De, sir. 3rd July, sir. Yes.
No, it is 11th of December 24.
11th of December 24.
page number 120 page 120
In terms of my direction, show me the reasoned order which was communicated to you.
Well, this is the order which was passed. Kindly come to page
30th July.
No, 11th of December.
Page.
Page 120.
120 of the contempt application.
Annexure R3. My lord, may I read it, my lord? May I read it, my lord?
It shows no reasoned order was
Yes,
passed.
my lord. Your lordship was directed for a reasoned order.
Then what is this, sir? Compliance report, page 5.
Compliance report.
Page 5.
The compliance report. Page 5 of the compliance report. Start with thereafter, my lord, if I'm not wrong.
So this is not the reasoned order?
No, this is only a report given to your lordship saying that something is just churning up in the particular property. That is not the case. The situation is that the parties, the persons who are entitled to the property have got no problem with them. They are the 3 petitioners and 2 other shareholders who will get 50% of the property. They have got no problem with them. I've got the letter. If you lordship so desires.
No, I cannot test the correctness or quality of the reasoned order.
No, I'm not saying that, my lord. I'm not saying that. You must say something which has got merit in the report.
You show
What
me
is
the,
coming
you
up, my
show
lord?
me the reason order.
According to them, this is the no reason. That is the only order.
120.
Yes.
Mr. De,
I,
take the microphone, sir.
My lord, your lordship will see my compliance report.
Yes.
That is, my lord, page 4, my lord. That is with reference to the above mentioned subject in compliance with the
I can't hear you. Take the microphone properly. Yes.
with reference to the above.
Page.
Page, my lord, 4 of my affidavit of compliance.
Page 4. Yes. With reference to above.
Page 4 দিলি
30 তারিখ
6th August 2025.
30th July. Page 4 is 30th July.
6th August 2025.
তাহলে আমাদেরকে এটা দেয়নি
এটা
এই
দেননি
পার্টটা
আমাদের।
নেই আমার কাছে
6th August.
এই পার্টটা আমাদের কাছে নেই।
পেজটা আমাদেরকে দেয়
Affidavit in compliance. Page 4 is a letter. 30th
Yes, ma'am.
July.
Letter 30th of July.
ইয়েস
এটাই তো কমপ্লেন্ট। এটা আপনাদের না সুমন প্রধান অন বিহাফ অফ দি শুভ্রজিৎ।
হ্যাঁ ঠিক আছে সেটা ঠিক আছে কিন্তু এখানে আমাদেরকে দিয়েছেন যেটা সেটার ভেতরে তো ওই
একটাই তো আছে।
আপনি পেজ 4টা খুলুন একবার
এটাই তো দেখছেন।
কেমন
6th অগস্ট
6th August তো?
হ্যাঁ 6th August।
এটাও তো 6th August।
হ্যাঁ
এর অ্যানেক্সের কই? আমরা তো অ্যানেক্সের পাইনি।
হ্যাঁ এই পেজটা কিন্তু লাগানো নেই
আমরা পাইনি।
এই পেজটা লাগানো নেই, পরের পেজটা আছে।
পরের পেজটা এটা 4 হয়ে গেছে। তো এটাও নেই। এই পেজটাও নেই।
এই পেজটাও নেই
This annex is missing, my lord.
এন্টার
Yes, this is here, page 6. 30th of July 2025.
উল্টে গেছে
It's page 4 in my brief.
In my brief, it is page.
Doesn't matter. Tell me.
Well, it is after all, it is there.
Tell me.
with reference to the above mentioned subject in compliance with the order dated ato connection with ato a reason order has been passed by the deputy controller Kolkata district refugee relief and rehabilitation. That is-
30th July.
yes my lord.
Acha.
30th July.
Now 30th July is available in the next page.
In the
Yes,
next
madam.
page 7.
উনাদের ক্ষেত্রে একটু এদিক ওদিক।
Yeah, whatever it may be.
Doesn't
Found it,
matter.
it's all right.
Doesn't matter. My page 5.
Yes my lord. By solemn order of the past of the Honorable Justice, my lord, High Court Calcutta in respect of the ato in the matter of Swapna Rai Chaudhuri and Atar, the respondent number 4, who has concluded the hearing is directed to communicate the reason order to the petitioners positively within
Where you are reading? Then the respondent number 4 who has concluded. Proceed.
concluded the hearing is directed to communicate the reason order to the petitioner positively within a period of 4 weeks
Correct.
from the date of communication of this order. In the event,
So let us not read up to that. Now kindly come to from that page accordingly.
accordingly in compliance with solemn order in past in ato, the petitioner were served with the findings of such hearing dated ato and memo number ato. One Srimati Joylokhi Rai, since deceased, wife of Nipoti Bhushan Rai, is or was the recorded original plot holder of RR land of UP number ato. Ato Bijoygar as per record mentioned in this office. This office has received several prayers for issuing my lord, final freehold title deed from different persons claimed to be legal heirs and family members of Sri Joylokhi in connection with the said plot. The office has on several occasions verbally suggested the claimed legal heirs or family members of Srimati Joylokhi Rai to settle their family dispute in connection with said plot in question amicably. However, they failed to achieve any solution in respect of their family. This is very important, my lord, that portion. In order to ascertain cause of such family dispute, a suo motu hearing was conducted on ato by memo number ato by the deputy
Sir,
controller. Kolkata.
straightway come to last page
Yes, my lord.
and read loudly the process of regularization.
The process of regularization issuing the freehold title deed of the said plot could not be progressed further due to the family disputes among legal heirs, relatives of the original plot holder. In terms of geo number ato may be quoted here.
the implementing authorities should not engage themselves suo moto in settlement of disputes. The disputing parties should rather be asked to find a common accord among themselves. Unless the dispute in regard of rival claims as to right of title, sharing of land, and manner in which the plot is to be divided, subdivided, etc., are settled amicably by the parties themselves, conferment of right title to such dispute parties should not be undertaken. Amicable settlement of dispute parties are necessary to issue freehold title deed. In this case, there is no amicable settlement.
Yes, yes, Mr. Dev. So, Mr. Mukherjee, it appears reasoned order has not culminated into a decision because there is a family dispute.
Actually, there is no family dispute.
That is not to be looked into by content court or by the writ court.
That is true. My lord, they have put in this family dispute, whereas we had no family dispute.
No, that I cannot say. Content court cannot say, neither the writ court.
My lord, your lordship was pleased to grant us a leave to take out exception. We have taken it. We served the copy earlier.
On the prayer of Mr. S.P. Mukherjee, learned senior counsel, time to file exception to the compliance report. Time to file exception to the compliance report stands extended till today, full stop. The exception filed in the form of affidavit is taken on record. Full stop. So my thinking is I cannot help you anything in contempt jurisdiction.
No, my lord, my respectful submission is that if the LLR, you know, BLLR, no, RR department just takes up an issue which was not there, then what
content court cannot do it.
I appreciate that we have to file a fresh writ.
That's up to you, fresh writ or suit. It's for your client to decide. Ashud.
Huh?
The order dated November 5, 2024, where from?
If my friend's client would have agreed that this is a situation where freehold title deed can be given to two parties, things would have been over a long time. No, I appreciate the court cannot do it.
My lord, I may not.
Let me pass my order. Let me pass my order. I will add a rider.
Yes, my lord.
Let all of you hear that. Then, if you have any further submission, both of you, I will hear you.
No, my lord, I may not want to. In contempt matter, I have not any right to say anything.
You will know. Miss Obi, the instant content proceeding has arisen. Has directed the respondent number 4 in the writ petition, who is the contemner here.
Yes,
contemner.
One contemner.
One
Who is the contemner here to communicate the reasoned order to the petitioner within the time frame mentioned in the order. First up, it was also stated in the order, it was also directed in the order, if the reasoned order goes in favor of the writ petitioner, then the alleged contemner and or any other appropriate state authority to take steps to implement the same. Post paragraph. The compliance report by way of an affidavit affirmed on August 6, 2025 by the alleged contemner contains the reasoned order dated July 30, 2025. First, after a long discussion, the authority came to a finding that as there are family disputes amongst the co-sharers of the property, alleged co-sharers of the property, freehold title deed could not be executed. Mr. Shiva Prasad Mukherjee, senior advocate appearing for the petitioner, relying upon the exception filed by the petitioner, submits. Relying upon the case made out in the exception filed by the petitioner, submits that there is no family dispute at all, and the authority is simply avoiding to issue the freehold title deed. This is the contempt, according to petitioner. Paragraph. After considering the rival contentions of the parties and upon perusal of the materials on record, this court is of the view that while adjudicating a proceeding under contempt jurisdiction, the court cannot test the quality or correctness of the reasoned order. Full stop. As in the facts of this case. Full stop. The contempt court cannot probe into the mental process of the authority who has passed the reasoned order. It will only see whether the direction of the court is complied in its true spirit and effect or not. Paragraph. Paragraph. On a scrutiny of the impugned order, or reasoned order dated July 3, on a scrutiny now. On a plain reading of the impugned order, July 30, 2025, this court is of the firm view that it cannot assess its quality or correctness, which is questioned by the petitioners. Paragraph. In view of the foregoing discussions and reasons, this court holds there is no contempt on the part of the alleged contender. Full stop. Paragraph. Accordingly, CPAN bold 443 of 2025 stands dropped and closed. Paragraph. The application bold CPAN 443 of 2025 stands disposed of. Stands dismissed without any order as to cause. Paragraph. However, this order shall not preclude the petitioner to take steps in accordance with law if he is aggrieved by the said reasoned order.
Item number 8, in this matter, I am appearing for the petitioner, Lordship. Order has been complied.
Come on, louder.
Order has been complied.
Petitioner.
I am for the state.
Mr.
Ishan Bhattacharya.
Ishan Bhattacharya, learned advocate appearing for the petitioner, submits that the Order dated
4th December 2024.
December 4, 2024, comma, wherefrom this content proceeding arose stands fully complied. Paragraph. Mr. Chundi Charan De, learned counsel, appears for the alleged contemner, has also confirmed this submission. Paragraph. In view of the above, comma, bold, CPAN 444 of 2025 stands dropped and closed. Paragraph. The application ওই একই number bold করে stands disposed of. Thank you.
দিদি দুটোতেই নাম দিয়ে দিয়েছি সাঁতার দিদি দুটোতেই নাম দিয়ে দিয়েছি সাঁতার
9, my lord, I am for the petitioner, my lord. But I'll pray for an accommodation, my lord. The exception, my lord, could not be affirmed yet.
আসুন, on the prayer of Mr.
Tutiman Banerjee.
Tutiman Banerjee, learned advocate appearing for the petitioner, time to file exception to the compliance report.
Absolutely, yes.
Stands extended till January 20, 2025,
Advance
2026. Mr.
Shayan Day, my lord.
Shayan
Day.
D-E.
DEY.
D-Y. Shayan De, learned advocate, appears for the alleged
Alleged contemner, my lord.
contemner. Full stop. The matter shall appear under the heading contempt application on February 20, 2026.
Published.
Next.
Item number 10, Mr. Shankar Prasad Dolopati is leading me. Well, I was praying for a 10 minutes passover in this matter.
Sir, I don't believe in that local 10
My lord,
practice.
then my lord kindly takes up the file, my lord. My lord, he will join. My lord, your lordship was kind enough to pass an order on the last occasion. Add
If you can take, if you want for a Passover, it will be passed over for the day.
My lord, then kindly, my lord,
I
takes it
also,
up.
my lord,
Take it up.
I also, my lord,
You
praying
can
for
come on the next day.
My lord, because my lord, the predicament of the petitioners was my lord, accepted by your lordship on the last occasion, and your lordship was kind enough to grant us leave to add the principal secretary or as the chief secretary party, so that the compensation that was awarded long back could be my lord paid to us on the score, my lord.
Yes.
Of the cabinet taking a decision.
Mr. Nilot Polchat.
Take microphone and make
Mr. Nilot Polchat is appearing for the alleged contemners, my lord. My lord, he is on his way, my lord. He was praying for Passover, but he is on his way, my lord, to me for this.
Very well.
He is coming, my lord.
Passed over for the day. Come on the next day.
My lord, what has happened, my lord? May I, my lord, take this, my lord? The cabinet had taken a decision. My lord, deputy secretary has written to the concerned authorities in the month of October to release the payment. My lord, we have been served with this with a letter. Probably they have also have that knowledge because it's their communication.
Come on the next.
But I was
So
praying for a rule.
You've got your.
No, well, we have not got
Let's say
anything since 1990s.
No, cabinet taken when? Cabinet
But
decision?
we do not know, but the letter suggests that the cabinet taken a decision.
All right, let's see.
And I was praying for a rule then, my lord. If
All right, let's see. On the next day, let's see.
so very good.
এটা কিন্তু Passover, হ্যাঁ, পরের সপ্তাহে থাকবে।
Item number 11, praying for not.
First day.
No, second day, my lord. Praying for not this week, my lord.
Not this week. Passover for the day.
I am for the petitioner.
First time.
No, second.
Second time.
Pursuant to lordship decision, I have served. Well, yesterday the building has been demolished, but the materials has been stacked on the same plot of land, where my ingress and ingress affected.
Let me see the order. Yes, Mr. Chatterjee, come. Chalo, দেখি next matter. Nah, just let them. Sorry, blood stuck.
কোন মামলা?
ওই আগের টার্গেটটা 10 নম্বর।
এই ব্রিফ সার্ভিসটা দিয়ে
এটা কত নম্বর?
10 মিলোটাও
10. Yes. Have you disclosed it through on record? No, no, my lord.
My lord.
You have disclosed on record.
No, no.
This letter?
No. It's just
Come on record. Let it, please, let it come on record first. Ashun. Mr.
Pritam Chaudhary.
Pritam Chaudhary, land advocate appearing for the petitioner, submits that the cabinet, that by a letter date, from a letter dated
My lord, letter dated, my lord, 14th of October 2025.
14th October 2025, addressed to
The Joint Secretary, Irrigation and Waterways
the
Directorate.
Joint Secretary of the Irrigation Department, issued by
The Deputy Secretary, Land and Land Reforms and
Deputy
Refugee
Secretary, Land and Land Reforms Department,
and Refugee Relief and
Land
Rehab.
and Land Reforms Department. কি বললাম?
My lord, the letter suggests that
Wait. কি বললাম? That শুরু করেছি Pritam Chaudhary submits that. It appears that the cabinet has taken the relevant decision for releasing the compensation. তাই তো?
it was directed, my lord, that take necessary action for placement of required funds at the disposal of the DM. My lord, the
About
Cabinet has taken some decision on the subject matter in content.
I'm going to come back on this one.
Full stop.
oppose করবে তাহলে কাম ব্যাক অন দিস বলছো তো
The said document is not on record. Paragraph. The petitioner shall file an affidavit disclosing the said document on or before আজকে কত?
I shall file it, my lord, by week, my lord, but by next week.
আজকে 14 on or before November 26, 2025, upon a copy being furnished to the alleged contemner. How many? Alleged contemners. And Mr. Nilotpal Chatterjee, learned counsel representing the contemners in this matter. Post up. Mr. Chatterjee shall take necessary instruction and revert back on the next day. Revert back to this court on the next day. Full stop. The matter shall appear under the heading content application
দাদা বলছে ক্যাবিনেট ডিসিশন নয়
on
দাদা বলছে ক্যাবিনেট ডিসিশন নয়
কবে বলেছি অ্যাফিডেভিটটা 26 নভেম্বর December 5th December 26 November you will file the affidavit disclosing that letter and upon copy to them 5th December 5.
Lord, whether they are denying this letter, my lord, without issue.
I do not know.
Lord, we complied with your lordship's last order. All the orders we complied with. Without issuing rule, my lord, they will not pay.
All right, you first serve this or letter. Let us see, sir. So hurriedly, so many things cannot be done.
Lord, 2 years gone.
All right, I appreciate.
Lord,
come back, disclose this on record.
my clients losing confidence over me. Although I have the confidence over the court.
And the court has the confidence over the system.
We all have.
Don't worry. আচ্ছা ওটা মিস্টার দলপতির নাম দিয়ে দিন প্রীতম চট্টোপাধ্যায় led by Mr. শঙ্কর প্রসাদ দলপতি
Pritam Chaudhary.
Pritam Chaudhary led by Mr. Shankar Prasad Dalapati.
But I will claim the interest over that money.
Yes,
and that will be the burden of the public exchequer. No officer will pay this since 2024 after
Don't
determination, my lord.
Be little sympathetic to the public exchequer. Don't claim.
My lord, because of intentional harassment of the officers, my lord.
Let the document come on record. How can I see? How do not? I have also not seen it. Let's see. Come on record. Next.
Instead of 8th pilot, maybe come back on 12th pilot.
No, no, no.
No, December 5. Next.
But again, on the next day, they will come with new region, my lord. In this way, the matter to be.
Let's see what to do, sir. Some matters, something we have to depend. We have to follow the procedure of law at least. What to do, sir? Unless that comes on record, then you should have
this
disclosed
letter
it in your petition.
My lord, in a contempt petition, my lord, this letter, my lord, your lordship directed me. That's why I will file affidavit. No problem. But my lord, in contempt proceedings, my lord, this letter, who will opposing this letter, my lord? The
They
chief
do not
secretary.
know. They
I
do
said
not
this is
also
not the
know.
cabinet
They
decision.
Come.
Lord, whether the cabinet took the decision or not, my learned friend don't know.
I'll come back. I'll come back.
Therefore, my lord, the
আচ্ছা,
rule
ওখানে
to be
আরেকটা
stood.
লিখুন। কি বললাম নীলোৎপল চ্যাটার্জি লাস্টে কি বলেছে?
My lord, the cabinet decision not to be see the light.
Not a yes. This is not a cabinet decision.
No. Definitely cabinet decision. Last order to that.
He shall also inform what the whether the cabinet has taken any decision on it, and if not taken, then what is the reason for the same?
Well, that is why the chief secretary to be.
Right, all right. কি বললাম?
We'll come back before lordship.
One thing, if the court is not satisfied with the explanation on the next day, if the court is not satisfied with the explanation to be provided on behalf of the alleged contemners on the next day, comma, this court may proceed in accordance with law.
Lord, at least 5 times your lordship passed this order.
What to do, sir? What to do? Some document unless on record, how do I? And if it is a
Lord,
decision,
no instruction
sir,
is with my landed.
can the court mandate the cabinet? You take a decision.
No, my lord.
So if they don't take decision, what will happen? You tell me.
My lord, the court can issue the rule and can direct.
Presence will not help, my lord. He is persistently harping on.
Lord, Joint
Chief
Secretary.
Personal appearance.
No, but if necessary, he has to be present.
Certainly. Financial.
Let's see. Next.
Sorry, my lord.
No, why sorry? You have done your matter for your client. Absolutely.
এটা ধরবে
এই পেছন থেকে বললাম না দৌড়ে আসছে
Yes.
My lords order, therefore I serve notice. Yesterday, my lord, the building has been demolished, but the building materials has been stacked over the said plot of land.
Let me see the order.
Whereas my egress and egress now serial is affected.
That cannot be a ground for contempt. Let me see. The order passed.
Or say page 15 of my content application operative part, page 17. In the event.
Wait. Yes.
In the event, the region order confirms the unauthorized structure and encroachment on the public land, the respondent number 3, that is the SDO, shall take necessary and consequent steps to give an immediate effect thereto.
Then
page 18, the region order. Operate. Last paragraph. Order. The respondents are directed.
Show me the reason order.
Page 18. Last paragraph.
Yes.
Last paragraph. The respondents are directed under section 4(1) of the West Bengal Public Land Eviction of Unauthorized Occupants Act 1962 to remove unauthorized encroachment caused by them from
So
the
demolition made,
demolition made.
removal took place, but the debris are lying.
My ingress and egress, my I have filed a writ petition that my ingress and egress affected, so that I filed a writ petition.
Why don't you remove the debris?
But the other side prevented to us.
Who is the other side?
Other side, the private respondent, along with the police authority, my lord. OC of the concerned police station, that is the Moisadal PS, is involved with this matter personally.
No, how can I read the order? Now you tell me that I have a power to issue that remove the debris.
Yes, my lord.
Yes, show me from the order that is the contempt.
My lord, this is the encroachment.
Mr. Counsel, let us concentrate on the order. Come and read the order at page 17.
Page 17, my lord. In the event the reason order confirms the unauthorized structure that has been demolished and the encroachment on the public road,
Come on, your interpretation will not help. Read the order.
structure or encroachment on the public land, the respondent number 3 shall take all necessary and consequential steps to give an immediate effect thereto positively within the period of 3 weeks from the date of said reason order to be passed.
So reason order passed, demolition has happened.
Well, the consequential steps has been mentioned in the order.
Yes, consequential is the demolition. Not one after another brick he will collect and remove. He will collect and remove.
My lord, my main prayer of the writ petition, my lord, kindly.
This is an order, content proceeding arising from an order dated September 26, 2024. First paragraph. The reasoned order annexed to the writ petition at page 18, dated March 6, 2025, shows that the unauthorized construction has been demolished by the alleged contemnor in accordance with law. Paragraph. However, the petitioner submits that after demolition, the debris are still lying, which are resisting the free egress and ingress of the petitioner to his dwelling house. Full stop. Paragraph. In view of the above, the petitioner may make a request to the local authority. Who is the local authority? Municipality.
Panchayat.
The local authority to remove the debris upon payment of usual charges and costs being to be paid by the petitioner. Full stop. And the proper money receipt shall be issued to the petitioner in the event such costs and charges are paid. Paragraph. However, the above direction shall not create any right or equity in favor of the petitioner and the petitioner cannot initiate any content proceeding for the same. Petitioner shall not initiate any content proceeding arising out of this direction. Paragraph. Nothing further survives in this writ petition. Paragraph. CPAN 1198 of 2025 stands dropped and closed. আচ্ছা মাথায় লিখুন একটা, this order shall not be treated as a precedence. This order shall not be treated as a precedence. Paragraph. CPAN 1198 of 2025 stands dropped and closed. Paragraph, the application, our bold coding stands disposed of.
Order has not been completed.
There are ways and means. Apply your mind in law, which is beneficial for your profession also. There are ways and means in law.
It has been complied with. My lord,
Kindly see the order dated 24th of September 2025.
I am contempt.
This
I
is
have to justify because
Milord,
petitioner has
just I am placing the Milord
No,
the
my lord,
previous order.
Let me order.
Yes,
Kindly see the order.
My first
my
order.
first order, my lord, page 25. Page
Wait,
25.
wait.
Yes.
Order dated 24th of September
Where first
2025.
25.
Wait.
Original order.
Show me the order where from content
Yes,
arose.
25. Page 25.
চিৎকার করছো কেন দাঁড়াও
আরে
না
বাবা একটু পড়তে হবে
তার মানে
আসল
কিছু নেই।
কিচ্ছু নেই তাই জন্যই তো তোমার
কিছু নেই বলেই চেঁচাচ্ছে।
না অনেক আছে my lord kindly recall or
Kindly have a look at page 25 of the content.
Let me see. Place 25.
Yes.
Place.
Such and such evidence none appears for the respondent despite service. This order shall be effected subject to payment of remaining 3 individual court fees to be paid by the petitioner. Sole grievances of the petitioner is that since the quantum of compensation have not been enhanced by the jurisdictional civil court, the petitioner have initiated proceeding under section 28A of the Land Acquisition 1894, and the same is still pending before the respondent number 3. In view of the above, kindly see, respondent 3 is directed to dispose of the said application of the petitioner annexed to the writ petition by passing a reason order in accordance with law positively within a period of 6 months from the date of communication. This line, after
Please,
this line is
next.
very important. It is made clear that this court has not gone into the merits of the claims of the petitioners made in the said application filed by the petitioner under section 28A of the Land Acquisition 1894, and the jurisdictional authority shall decide the same independently in accordance with law.
Now you take your seat.
Yes.
Don't talk, take your seat. So this is the order, sir. Now first you show me whether they have.
I want to draw your.
First ask him.
My.
Hear you. First you show me that no reasoned order has been passed. The first act of contempt. That no reasoned order has been passed. Show.
Reason order has been passed. Has already been passed.
So first part compliant.
No.
Now you make your submission.
In view of the above, the respondent number 3 is directed to dispose of the said application of the petitioner being annexure P1, page 11, such and such, by passing a reasoned order. Next is important. In accordance with law, positively within a period of 6 months. Neither it has been made within 6 months, nor it has been made in accordance with law. It is admitted that it has not been done within 6 months. So there is a Milord contumacious act on their part. Next is not in accordance with the law. Kindly have a look at the Milord recent order.
Now you show me the law first. Argue on the point of law that according to you it is not in accordance with law.
No, it is evident from the document itself, not according to
you show me that while I am adjudicating a contempt proceeding, I can assess the quality of the order.
I am not, Milord, I am not seeking your lordship or not impressing upon your lordship to see the quality of the order. I am seeking only your lordship to adjudge whether it is in accordance with law or not.
Sir, how do I know? If I say in accordance with law,
accordance with law means
it may be X according to you.
No.
It may be Y according to him. It may be Z according to me.
Subject to lordship's kind correction. If I place it in a different way, law prescribes that certain thing is required to be done in 4 stages. 4 parameters has been laid down by the court. It is not I. So these 4 parameters ought to have been there while passing the reasoned order. It appears from the order itself that this is a nothing but an order for disposing of an application under
Mechanical order, mechanical.
No, not that, not that. It is not simplicity and mechanical. It is a disposing of an application under section 28 capital A. That is the enhancement of a compensation on the basis of a reference court order. Reference court stated you will get 1, 2, 3, 4, 5. 4 has been given, 5 has not been given. So therefore, no, my lord, the examination is required. Only it has not been, my lord, made in accordance with the law. It is evident from the document itself. What I am saying, my lord, it is the component of the statutory provision.
So I will have to set aside this order. Holding.
No. Your lordship has to give a direction to the authority that this is not a, my lord, in accordance with the law, and come with a further, my lord, the report complying that order. Because, my lord,
so what will happen to this order?
This order will be there because by strength of the order, I have already, a certain amount has already been credited. The interest portion, which is the 5th one, that has not been given.
Very well. Would you challenge it in a fresh writ petition if you are aggrieved?
You know, only the thing is this.
Sir, I will not adjudicate this point in contempt. I will hold against you. I will give my reason. I will record your submission. Whatever submission you want to make, I will record. You are free to make. And I will give my reason. This is not a content.
My lord, do that. Kindly hear me, record my submission,
absolutely,
and reject my submission.
Absolutely, absolutely. You are welcome, sir.
My lord, I have already drawn your lordship's attention that the rescind order within 6 months, in accordance with law.
Right. Accepted.
On 24th, the order was passed on 9th of December 2024.
Correct. 9th or 19th?
9th of December 2024, appearing at page 25 of the writ petition.
Correct. Oh, my order. Yes.
That has been communicated by a letter.
I accept 6 months beyond. I accept that.
So this is my submission is this. It appears from the document itself that within the 6 months that has not been.
I accept that.
Therefore, there has been a contumacious act on the part of the alleged contemner. Next one. Kindly take trouble to have a look at, my lord, their rescind order.
Page 8. What number?
Page 8, my lord.
Yes.
Original copy is with my lord.
Huh?
Original copy of the rescind order is with my lord.
So what is this? This is a Xerox.
Page 8.
This is
all right.
My lord, I am drawing your lordship's attention in the second paragraph. In view of the above finding, it is evident that the subject land of the writ petitioner is covered by the same notification under section 4(1)(a) of the Act 2 of 1948 in the LA case number LA 2 of 2022, 1988 and 89 as of the case of the LRA 62 of 2001 and 63 of 2001-5. The claim of the petitioner under section 28A of the Act 1, 1894 claiming redetermination of the compensation under section 28 capital A as per the order of the enhancement of the compensation passed by the learned LA judge in LRA case number 62 of 2001 and 63 of 2001 passed on 31st of August 2017 has merit. In view of the above, it may be held that the petitioner claim satisfied the condition of the filing the petition within the prescribed time, and the land under claim is also covered by the same notification under section 4(1) capital A of the West Bengal Land Acquisition and Acquisition Act 1948. But the criteria as to whether the awardee, being the predecessor in interest, was aggrieved upon the compensation paid by the collector, the record shows that the compensation was received without any protest, and which may be considered that the amount of the compensation determined by the collector in a case was admitted by him. However, considering the object of the introducing section 28A, the prayer of the redetermination of the compensation as enhanced by the learned LA judge may be allowed. I hold, hence, the order that the redetermination of compensation of the applicant, being the legal heirs of the original awardee, may be made in respect of the component of the compensation as indicated herein above, as per the enhanced compensation passed in the LA judge in LRA case number 62 and 63 of 2001. Before parting with the case, they mentioned that the claim redetermination of such and such is on 8th of November 2017 and direction of the such and such is thus complied with. So it is their claim that has been complied with. Kindly take trouble to have a look at the milord. This is the order, milord, on the basis of which we are seeking for compensation. Only relevant portion I am referring.
Yes, yes. No, you make your submission. You are free to do.
Page 40, page 2, milord. Milord, ordered. Kindly see, milord, last three pages.
Yes.
Ordered. The present reference application is allowed on contest. The market value of the Sali class of the land is assessed 17,600 per kata, Doba, such and such bill, and the bond classes and the such and such in the assessed rupees such and such per kata. Accordingly, award of the LA collector stands modified. 1 compensation rupees such and such. Then, milord, 9% of the said possession of such and such 2. Additional compensation 12%. Solicium 30%. Next is very important, which has not been awarded to me. Interest at the rate of 9% per annum for the last date from the date of the notification on land value plus SA, money solicium, and additional compensation plus rent and compensation together with 15% of the per annum from the subsequent period till payment as per section 28 of the Land Acquisition Act. So, milord, the collector ought to have considered it in view of this judgment. There are 5 parts in law. It is not my submission. So out of 5 parts, they have only awarded. Come and have a look at page 10 of the milord, their present order.
Yes.
Milord, enhanced value has not been mentioned. So, milord, I cannot agitate over here because this is a contempt jurisdiction. But what I can show, enhanced value plus 30% solicium, 1. RC 9% enhanced value of the rate such and such of the 10 years. Then, milord, 3% of the collector's land value. Additional compensation of the 12 enhanced such and such of 7 months. Then grand total. So, milord, the point of interest of the 9% per annum of the first year from the date of the notification of the land value plus solicium such and such together with 15% interest, this component has not been awarded.
The interest component has not taken into consideration.
Fine. This is, so therefore, milord, it is not in accordance with the law. I am leaving to your lordship, milord. I can agitate. Milord, 2 folds, milord, there in a contempt jurisdiction is normally being filed for the enforcement of the order, at the same time to award punishment to the contemners. So I am having, milord, 2. So far is the, milord, the contempt is, there is a contumacious act and this is a constitutional court. They have violated the order admittedly, but not acting it within the time. And the second one that has not in accordance, since, milord, as per the prescription which has been given in the order, that has not been complied with. It is my respectful submission. I am leaving the matter to yours.
This is a contempt proceeding arising from an order dated December 9, 2024. So, no further submission? Thank you, sir. Arising from an order dated December 9, 2024. Annexure A at page 19 to the contempt application. The relevant directions from the said order dated December 9. কি বলেছি দিদি? ভুল বলেছি। December 9, 2024. The relevant direction from the said date order dated December 9, 2024 is quoted below. Now, লিখুন the relevant observation and direction of this court from the said order dated December 9, 2024 is quoted below. Quote. Page 25, quote 1. Hello? Paragraph. On the basis of the said direction, now pursuant to paragraph, pursuant to and in terms of the said direction, the alleged contemner has passed its reasoned order dated January 14, 2025.
It starts from 19 December 2020.
Huh?
It starts from proceedings started by pursuant to madam. I kindly see the
Show me from the record where it is annexed.
The order sheet malad kindly see malad the I have handed over.
Handed over separately.
Yes, separately kindly see.
ঠিক আছে চলো
19 December 2024 it's commenced malad the proceeding.
ভাই কবে পাস হয়েছে সেটা তো
না না ওটা থেকে তো আরম্ভ আরে
Impugned order is on dated January 14.
January yes but malad it started on comments on 19
মিস্টার সেনগুপ্ত ইনোভেটিভ
এটা তো স্যার জশাক জানে
আমরা জানি
with the following finding. Quote 2. Full stop. তলায় লিখুন এই যে কোড 2 full stop তলায় লিখুন copy of the reasoned order dated January 14, 2025 has been placed before this court by Mr. Shushobhan Sengupta, learned
সিনিয়র
Senior?
এজিপি additional
senior advocate
no my lord learned additional advocate general now has been
advocate general advocate general but
আরে লিখে দিলেই হলো
হ্যাঁ লিখে
জুডিশিয়াল নোটিশ নিলেই হলো অ্যাডভোকেট জেনারেল
malad senior government advocate আপনি
সিনিয়র গভর্নমেন্ট অ্যাডভোকেট লার্নেট কি বললো
হচ্ছে তো কালকাটা নোটিফিকেশন বেরিয়েছে বাবলা মহারাজ কেটে গেছে
Learned senior government advocate, comma, the same is taken on record. Full stop. Paragraph, Mr.
শুভব্রত দত্ত
Shubhabrata Datta, learned counsel, appearing for the petitioner, has also admitted the said reasoned order having been passed. Full stop. Paragraph. Referring to this said reasoned order, Mr. Datta, learned advocate appearing for the petitioner, has submitted that the alleged contemner has acted in violation of the direction of this court in a contumacious manner for the reasons as follows. Colon niche, N, A, small a. The reasoned order was not passed within 6 months from the date of communication of the direction of this court. Semicolon, and Roman 2, niche. The reasoned order has not been passed in accordance with law, as mentioned in the order date, in the direction of the, as mentioned in the direction dated December 9, 2024. Paragraph. Learned advocate for the petitioner submits. Learned advocate for the petitioner then has placed an order of the collector past dated. Order of the collector dated.
Not the collector, my lord, LA judge.
LA judge. Order of the jurisdictional land acquisition judge dated, not 24 Parganas, dated
18th of September 2017.
September 18, 2017. Comma, the same is taken on record. Referring to the said order passed by the LA judge, learned counsel for the petitioner submits that while enhancing the compensation for the acquired land, the learned LA judge had held that the petitioner are entitled to fivefold of reliefs, which are mentioned therein. By showing a comparative study of the reasoned order and the said order passed by the learned LA judge, learned counsel for the petitioner submits that the awarding of interest as held by the learned LA judge has not at all been considered in the reasoned order passed by the alleged contender. Therefore, the reasoned order is not in accordance with law.
Interest component has not been awarded. Which has
not been considered, I said. Has not been considered and awarded. Not been considered and awarded. No, holo na. Sentence ta podun.
Extremely sorry, Miller, for interjecting.
And awarded in the reasoned order passed by the alleged contender. Full stop. This, comma, according to the learned counsel for the petitioner, is not in law as directed by this court in its direction dated December 9, 2024. This is your submission. Paragraph. On the strength of the above submissions, learned advocate for the petitioner, যে কোনো একটা phrase use করবেন, হয় counsel নয় advocate. আমি দুই জায়গায় বলে ফেলেছি. Learned advocate for the petitioner submits that contempt has been committed by the alleged contenders. Paragraph. After considering, Mr. Shushovan Sengupta, learned advocate appearing for the alleged contender, submits that the reasoned order has been passed strictly in accordance with the direction of this court and there is no contempt. Paragraph. After considering the rival contentions of the parties and upon perusal of the materials on record, comma, this court at the outset, comma, reiterates the settled legal position for adjudicating a contempt proceeding. Also, a court, while adjudicating a contempt proceeding, shall not travel beyond the order and the direction passed by it. the court cannot assess the correctness or quality of the impugned order, comma, a reasoned order, comma, as in the instant case. The phrase, comma, in accordance with law, cannot be defined in a straitjacket formula. Full stop. Understanding of law and perception of law may differ from individual to individual. Full stop. If the impugned order, comma, as in the instant case, suffers from any legal infirmity, comma, as submitted on behalf of the petitioner, comma, the petitioner may take legal recourse to it by challenging the same in accordance with law, but not in a contempt jurisdiction. Full stop. The authority, while passing the alleged contender, while passing the impugned order, a reasoned order, might have committed, might committed error of law, or has passed the order without appreciating the actual legal provision. But that cannot be gone into in a contempt jurisdiction. First paragraph. On perusal of the reasoned order, this court is satisfied that direction of this court has substantially been complied with by the alleged contender, and the material compliance is there, though the same was not considered within the time frame of 6 months specified by this court. Since material and substantial compliance is there, and considering the grave punishment and consequences of a contempt proceeding, comma, this court is of the firm view in the facts of this case that sufficient compliance has been made by the sufficient compliance of the direction of this court has been made by the alleged contender. Paragraph. It is also made clear that this court has not gone into the merits or the correctness of the reasoned order dated
14 January 2020.
2025. And if the petitioner is aggrieved with the same, the petitioner shall be at liberty to proceed to challenge the same in accordance with law. In view of the above discussions and reasons, this court holds there is no act of contempt. Paragraph. Accordingly, CPAN bold Didi 1255 of 2025. বাহাদুরকে ডাকো তো আমি উঠবো একবার 5 মিনিট।
এই ডাকছে
বাহাদুর, CPN or 1255 of 2025 stands dropped and closed, drop bold, closed bold. ভুলে যাননি তো? Paragraph. The application CPAN bold 1255 of 2025 accordingly stands dismissed.
One submission, may I submit one thing? Only one two words, if otherwise eligible. My lord has given
I've
liberty.
said in accordance with law, sufficient. If it is not accordance with law, you go and take the point.
Obliged.
Thank you. No.
For 14, my lord, I am appearing for the petition, my lord. This is the
First time?
First time, my lord. When new incumbent has to be added, my lord. New incumbent has to be added, my lord. First.
Mr.
Obhirup Bhattacharya.
Obhirup?
Bhattacharya.
Take the microphone.
Oh, sir.
Microphone. Obhirup Bhattacharya, learned advocate, appears for the petitioner. Paragraph. This is a content proceeding arising from an order dated
Order dated, my lord, 12/2/2025.
June 12, 2020.
No. February 12, 2025.
February 12, 2025. Properly address the court with the microphone. February 12, 2025. Today is the first day. Paragraph. আচ্ছা ওই আমার একটা আছে না যেটা বলেছি অ্যাফিডেভিটটা লিখবেন না শুধু লিখবেন কমপ্লায়েন্স রিপোর্ট পরে এখন না এখন দরকার নেই কি বললাম ফার্স্ট ডে প্যারাগ্রাফ learned counsel for the how many contemners?
One contemner.
Learned advocate appearing for the petitioner submits that the existing alleged contemner in the content proceeding is no more available due to transfer and the new incumbent has come. Full stop. Sri, new incumbent.
Reena Ghosh. Reena Ghosh.
Spell out.
REENA, Reena Ghosh. GHOSH.
Srimati Reena Ghosh is the new incumbent. Full stop. Paragraph. The petitioner shall implead the said new incumbent as an alleged contemner in the cause title and the original in the cause title and the content application wherever it is required by putting the signature of the learned advocate on record for the petitioner. Paragraph. The petitioner shall serve a copy of the amended content application upon both the alleged contemners along with a copy of today's order and file an affidavit of service when the matter shall be taken up next. Paragraph. Pendency of this content proceeding shall not preclude the alleged contemners to comply with the direction of this court and to file compliance report in the form of affidavit হবে না শুধু compliance report affidavit দিলে দেবে এমনি দিলে দেবে compliance report when the matter shall be taken up next পড়ুন প্যারাগ্রাফটা alleged contemners and to file a compliance report. Paragraph. In the event of non-compliance of the direction of this court, comma, this court may proceed to issue rule on the next day. Paragraph. The matter shall appear under the heading content application on February 6. No, February 6, 2020, February 6, 2025.
2026. 2026.
2026.
I shall amend the cause title here and now.
Yes, after 4:30. After the court hour. Next. Next.
I am for the petition of first time contender, please.
First time. আসুন একটা ফর্ম আপনার কাছে ফরম্যাট আছে ফার্স্ট টাইম অ্যাফিডেভিট কথাটা শুধু লিখবেন না আপনি দরকার হলে শুক্রশ্রীদির সঙ্গে কথা বলে নেবেন ঠিক আছে অর্ডার ডেটেড
4th December 2024.
ডিসেম্বর 4
2024.
2024 আর ওই বাকি সব এক থাকবে রিটার্নেবল করে দিন টু অ্যাপিয়ার অন February 6, 2025. 2026. Next. First time from the order dated
August 12, 2024. August 12, 2024. Or 4
August 12, 2024. How can you maintain?
I filed within time, 1 year.
Within 1 year. কি বললাম? August full stop. ওখানে একটা সেন্টেন্স লিখে রাখুন. The point of maintainability.
My lord, I filed in August 8, 2024. August 8, 2025.
The application has been filed on maintainability দরকার নেই. The application has been filed on
8 August 2025.
August 8, 2025. Full stop. বাকি তো সব ইয়ে হলো ফার্স্ট ডে
4 alleged contaminants.
ও ঠিক আছে যা পারো করো. February 6. Next.
Item number 17.
None appears. First time. দেখি আমায় দাও না. None appears for the petitioner nor any accommodation has been sought for. Full stop. That first time না. হ্যাঁ. Today is the first day. ঠিক আছে? তারপর ওই petitioner shall serve সবকিছু করে 6th February. February 6.
Item number 18.
ওই same. None appears for the petitioner nor any accommodation has been sought for. Today is the first day. করে ওই order. Next.
19, may I please, Lordship, I am for the first time, but
Order
here-
dated.
order
Order
date
dated
25th September 2025.
September 25, 2025. আর আসবে হচ্ছে 13th February.
My lord, 13th
Sorry,
Feb-
no.
my lord,
February
my lord,
13th.
kindly bear a moment. My lord, the medical examination is conducted from 12 to
Do it.
9
serve it.
December. My lord, I shall serve, but kindly, my lord, otherwise the petitioner will, my lord,
হ্যাঁ ফার্স্ট ডেতে বাকি সব থাকবে.
my lord, I shall comply with the lordship's order, but the returnable date should be given within, because my lord, medical examination will be concluded and they will publish the result and come with the
Contempt succeeds, then everything will happen.
well,
Status quo
contempt,
ante.
it is apparent on the face of the record, my lord, the contempt will survive. My lord, kindly give a direction on December. Otherwise, my lord, they will publish the and my lord, the complexity of this matter will come.
December
Otherwise,
is totally full.
my lord, January in the event of January, my lord, up to 9th December, the medical examination will be conducted.
Serve.
Yes, I must serve. I must serve it by Monday.
The final result will not be there before February.
No, my lord, they are going to publish the result by this year, because there is a rider to complete the proceedings within the selection year. That is the thing. Otherwise, I shall not desist your lordship to fix up the matter in December. As because they have set the date on 12th November to 9th December, it is my presumption that it is by end of this year the merit list will be published.
February 19. February হচ্ছে December 19.
Much obliged, Lordship. Grateful to Lordship.
Item number 20.
20, may I please, Lordship, I am for the petition, same, my lord, same regarding the same issue. It is also order dated, my lord, 25th September. 25th.
2025.
My lord.
December 19.
One.
21, my lord, I am for the petitioner. It is also order dated September 25th,
September 25.
2025.
2025. এটা করো January 2.
May I please, Lordship, I am for the petitioner. My lord, here the
Order dated
is Here, my lord, order dated 2nd July 2025. 2nd July. It is not related.
2025.
It is not related to this year. It is previous year, 2024.
Gone.
2024, my lord, your lordship's hold. Lordship hold we are. I am the withheld candidate. Put me my name in withheld release.
কি বললাম?
My lord, your
Good stuff. ওখানে একটা রাইডার করুন তলায়।
your lordship's hold that
This content petition pertains to the previous election year for the year
2020.
previous election year for the for 2023
2024.
for 2024. Full stop. The point of maintainability of the content proceeding is kept open.
No, my lord, within the time I have filed.
No, whether I can touch at all. Point of the maintainability of the content proceeding is kept open.
My lord, withheld list, my lord. My name was in the
See,
withheld
how
list.
to bother? Let it come. এটা করে দিন হচ্ছে জানুয়ারি 2
My deeply obliged.
আমরা খুলছি কবে বেরিয়েছে জানুয়ারি 2 তে
No, till date, no calendar was published. I think 2 will be the holiday because in the mid of the week it has been on
And that too Friday.
Wednesday is the 31st, I think. Yes, Wednesday is the 31st, my lord. It will be on Friday. 2 will be the Friday. I think 3, 4, 5, 5th. Our court will be open on 5th.
জানুয়ারি 30 করে দাও না আগের বলো না যা আছে যা বলেছি কি আর ঠিক আছে এটাও 2nd জানুয়ারি থাক না হলে হবে না কি করা যাবে তখন হবে না ঠিক আছে নেক্সট
23 also same, my lord. It's with regard to the recruitment process of 2024.
dated
Order dated, my lord, 7th July, 2nd July 2025.
জুলাই 2 2025 তারপর ওইটা লিখবে সিলেকশন প্রসেস অফ প্রিভিয়াস ইয়ার লিখে দিন আপনি যা বলেছি একদম ওইটাই লিখবে সিলেকশন প্রসেস অফ প্রিভিয়াস ইয়ার বলে যা লিখেছি মেইনটেনেবিলিটি কেপ্ট ওপেন ওটা লিখে রাখুন জানুয়ারি 2 2025
Much obliged.
26 জানুয়ারি 2 2026 সবকটা 6 হবে ইয়েস হ্যাঁ মোশনটা রাখুন আচ্ছা ইয়ে অ্যাসাইন্ড
Please, your lordship.
Yes.
My lord, I appear for the petitioner in this matter. If your lordship will kindly have my lord's last order dated 17th July 2025, my lord. By way of this order, my lord, your lordship had directed the petitioner to implead BL and LRO as a party and further directed BL and LRO to conduct the survey and then furnish a report. If your lordship kindly has my lord's last order, your lordship has expansively dealt with the issues and then passed an order.
Yes, then what happened? What
Yes,
did
my lord.
the proof?
Pursuant to my lord's direction.
DLRO, has he given hearing?
No, my lords, nothing, no steps have been taken. Your lordship will kindly have my affidavit of service. I have served upon them the amended writ petition, making them a
Come
party.
with the contempt.
Very well.
Why you have not come up with the contempt?
Very well. In that event, I shall do that because your lordship will kindly appreciate your
What
lordship.
is this?
This is my affidavit of service wherein I have served upon them the amended writ petition wherein I have made
Affidavit
them
of
a
service
party.
filed in court today,
And your
taken
lordship,
on
sorry.
record, showing service of notice upon the amended, upon all the respondents, including the newly impleted added respondents, including the added respondents. Full stop. The writ petition shall appear under the heading motion assigned. Now, তারপর লিখুন none appears for the respondents. Paragraph. The petitioner shall serve notice upon the respondents and file an affidavit of service on the next day. Paragraph. The matter shall appear, paragraph, the matter shall appear under the heading motion assigned on February 9, 2026. Hey, January 9, I'm sorry. January 9, 2026.
I'm so grateful.
Come up with the proper application.
Yes, I'll.
May it please your lordship, I'm appearing for the petitioners. I am seeking an adjournment on the ground of Mr. Kormukar, learned senior advocate.
Yes.
Could not be present today.
Huh?
Could not, sir, Mr. Kormukar, the learned senior advocate, appearing in this matter for the
Passed over
petitioners.
for the day. Next.
Next, try to.
I'm for the state respondents. Respondent number
None
one.
appears for the petitioner nor any accommodation has been sought for. The Mr. Rajorshi Basu, learned advocate, appears for the state. Paragraph. In view of the above, comma, the writ petition shall appear under the heading motion assigned on February 27, 2026.
February 27, my
2026. February 27, 2026. Next. Petitioner.
The pension of the petitioner was being withheld due to pendency of 2 criminal cases that has been already acquitted, honorably acquitted. Now there is nothing remains so far as the order is concerned.
But the disciplinary proceeding and the
Nothing. Everything has been no disciplinary proceeding initiated, but I have relied upon your lordship's order that in the pendency of the criminal case, if it is not related to the school, then it can be given. But still, my lord waited for the criminal case to be resolved, and criminal case, I have been acquitted in the criminal case.
Show me the, have you disclosed by way of an affidavit?
Yes, my lord.
The acquittal order?
Last affidavit has been filed, my lord. The acquittal order is there, my lord. Supplementary affidavit.
Where is that?
This is my supplementary affidavit.
On the prayer of Mr.
Sondipan Banerjee.
Sondipan Banerjee, learned advocate, appearing for the petitioner. Leave has already been granted previously. Show me which order.
For filing the supplementary affidavit, last order.
Done. Where is that, sir? Leave granted to you.
Last order was there. I will mention it at the time of after acquittal from the criminal cases. That was the order.
Sir, you show me that I granted you leave to file supplementary
No,
affidavit.
that I can show, that I can say. Your Lordship directed me, the petition is adjourned sine die. The petitioner will mention it immediately when that he will be acquitted from the 2 criminal cases. That is there.
Oh, that I accept.
Well,
আসুন কি বললাম সন্দীপন ব্যানার্জি leave is granted to the petitioner to file a supplementary affidavit disclosing the judgment of the jurisdictional criminal court whereunder the petitioner has been acquitted from the relevant criminal charges after trial. After trial,
completion of trial,
comma, the supplementary affidavit filed in court today is taken on record.
I served them also.
Have they take this, the jurisdictional district inspector school shall pass a reasoned order I directed. What happened to that?
That has been passed. Reason order has been passed regarding provisional pension. They have
show me.
My provisional.
Show me from kindly come to 24th April 2025 order. 24th April.
Now I am not pressing for the provisional pension. I am pressing for the finally disposal, because already as per the impugned order, it is annexed with the writ petition. They says that as the 2 criminal cases are pending, we cannot release the disburse the salary. Disburse the, that is that
writ petition. Let's
writ
go
petition,
to the writ
madam.
petition. Likun, you are appearing for whom?
For West Bengal Board of Secondary Education. West Bengal Board of Secondary Education.
WBS 31. Page 31.
Number? Mr.
Vivek Datta.
Vivek Datta, learned advocate, appears for respondent number 4.
I am led by Mrs. Bhattacharya.
Huh?
I am led by Mrs. Bhattacharya.
Which Bhattacharya?
Koeli Bhattacharya.
Led by MS Koeli Bhattacharya, learned advocate.
Last but one paragraph, page 31. Annexure P4, madam, in the writ petition.
Page
31. 31. Last but one paragraph. Yeah, read, madam.
Reasoned order.
Reason that is the order that I have challenged in the writ petition. Now that has become infructuous, because they says the alleged teacher is not eligible for final pension and gratuity till the final conclusion of the pending judicial cases.
Show me.
That is at page 31, last but one paragraph, madam.
Show me that memo 19.5.
No, I have already been acquitted in the said pending.
Kindly show me that memo.
That reasoned order, madam.
Sir, there is a reference of a memo in the reasoned order.
My lord, that is their reference, my lord.
That's right. It's a government order. Show me that. That's their reason for withholding.
Yes. Now, in terms of that, we have already acquitted, my lord.
Can I not see that?
Yeah, my lord can always.
Show
Then
me.
I have not ready with that memo. It is their memo. I am not ready, but still I should have been.
It's a memo of the finance department.
Finance department. That I am not.
Show me that.
Ajay, apna kache. Then madam, next day I will come with that memo again.
Who shall release the pension?
But the PPO will be released by the
authority, your employer.
employer.
Who is your employer?
Teacher in charge is my school, but employer will be, specific authority will be, my lord, the sub-inspector of schools, Khoirasol, having his office at.
That's all right. So the state must come.
State must come. State is.
Who appears for the state? তারপর লিখুন none appears for the rest of the respondents.
I have been debarred from getting the pension, a school teacher for 5 years. He is being debarred.
Yes, Mr. Dole. You take charge of the matter. None appears for the state. Full stop. তারপর লিখুন since a retired teacher has not been receiving his pension
and gratuity, anything,
and gratuity,
and that too for the not disposal of the criminal case that has been specified there. So I have already acquitted.
On the plea of pendency of a criminal case, on the pendency of 2 criminal cases, which have now been decided finally,
Honorably acquitted.
under which decided finally by the orders dated.
I am placing it. By the first order is 39/2024.
By the orders dated
39/2024.
September 30, 2024.
And the other order.
One second. Passed in Sessions case number 219 of 2019. By the learned Sessions Judge Birbhum. Annexure S1 at page 8 to the supplementary affidavit. And the second one, by an order dated
26/2025.
Page
32 of my.
Wait. Where is the judgment?
Immediately that follows the judgment, my lord.
Yes.
It is a page 34.
Tell me the order. And the second one being dated
26/2025.
June 2025. June 20, 2025. Passed by
Chief Judicial
Chief
Magistrate.
Judicial Magistrate, Shiuri.
Birbhum.
In
my lord.
CGR 26 of 2016. পড়ুন। একটু শুরুর থেকে প্যারাগ্রাফটা। Gratuity and pension. Since a retired teacher, লিখেছেন তো? হ্যাঁ, পড়ুন। Gratuity and pension. Annexure S3 at page 31 to the supplementary affidavit.
And another, I am sorry, my lord, another case on the same cause of action by the same person.
You said 2?
No, 2 means analogous to matters. GR 30 of 2016.
And the third one?
GR 30.
Which page?
Page 39.
Third one? And the third order?
Same date.
Dated?
26/2025.
Page?
Page 39.
Dated June 20?
2025.
Oh,
Same dates. Actually, analogous matter.
And the third one, also under the said order dated June 20, 2025.
In GR case number.
In GR?
Case number 30 of 2006.
Same number?
No, that is a different number. The person have filed 2 cases against him.
No, to second number ta bolun.
GR 30 of 2016.
Then third number ta?
That is the third number. And
second
second number is GR 26 of 2016.
আগে GR 30 টা হবে GR 26 করুন second টায় করুন
GR 26 is there, man.
হ্যাঁ
And next is 30.
হ্যাঁ so 2
3. First is 2019 that have already pronounced.
So in
first is dated 2019. That has been done already.
And the S3 and S4 are different.
S3 and S4 are different cases by the same person and the same cause of action.
June 20 said order under the order dated June 20, 2025, annexure S4 at page 38 to the supplementary affidavit, comma, Mr. Pinaki Dhol, Learned State Counsel, who is present in court, is requested to appear in the matter to hold the brief to assess this court henceforth. Poster. His appearance shall be regularized by the office of the learned government pleader forthwith. Poster. On the next day, he shall bring proper instructions with supporting records before this court so that the matter can be finally decided. Poster. If no instruction reaches to this court on the next day, then the matter may be proceeded on the existing record. Poster. Learned advocate on record for the petitioner shall serve a copy of the writ petition, comma, come on, tell me, writ petition, comma, affidavit exchanged.
Affidavit in the previous matter, no, in the original writ petition, they have not filed any affidavit.
Writ petition and the supplementary affidavit, along with the orders passed in the writ petition, upon Mr. কি বললাম একটু আগে পড়ুন সেন্টেন্সটা না the writ petition, comma, supplementary affidavit আর কিছু না ঠিক করে লিখুন the writ petition, comma, supplementary affidavit and the orders passed in the writ petition. Upon Mr. Dole, learned advocate, forthwith. The matter shall appear under the heading motion assigned. You have served supplementary affidavit to him.
I will serve today. In course of this, all.
If you don't serve, then again next day it will not be taken up.
Only that, Kohli Vorchas have been already served.
You have served?
Yes, sir. Only Pinaki Dhol will be served.
The matter shall appear under the heading motion assigned on December 19, 2025. Next.
At least this year, my lord, we can get.
Huh?
This year, my lord, we can get.
I don't know, sir. I have been assigned with a new determination.
But still, my lord, the person is suffering.
Maybe, but I have to give preference to the regular determination matter first. Then after that, if I can reach, I will reach.
Then, my lord, let it be taken up in the first week of December. Then, because 19 is a very risky date.
I cannot do, sir.
That date, it is very impossible that the matter can be called on.
Yes, maybe possible. Possible, though we have 2 other days thereafter before vacation. 3 days, 22nd, 23rd, 24th.
As your lordship. I leave it to your lordship.
But I have to give preference to my present list and determination. Yes, I'm coming back at 2. কত অবধি হলো?
directed to come at 2 p.m. for mentioning is for the extension of the interim order passed on 20.
Wait. Original side officers are not here. Wait, I will take up. Wait. Today we have a short innings, 3:30.
Yes,
So if I don't reach, mention before I rise. Which serial number?
39, Your Lordship. Of today's
39.
list.
একটু লিখে রাখো 39 আইটেমটা আলাদা করে রাখো আমি দেখে নিচ্ছি। Yes, next.
And I appear for the petition. This is a civil revisional application which has been
Civil revisional.
matter, Milord. This was released, Milord, on my ground for Justice Bhattacharya, Milord. These are, Milord, contested hearing matters.
Contested hearing?
Not now motion, but these I perceive, Milord, these both the matters, Milord, next matter also, Milord, this will take time. After service, Milord, this will take time.
Matter of inheritance.
This is, Milord, section 4 of the Partition Act.
Matter came to you by inheritance.
Recent matter. Recent.
Give notice and come back.
কি করুন প্রিভিয়ার পার্টিশন সুট
না আমার পার্টিশন না আমি ডিপেন্ডেন্ট
মিলর্ড kindly stay the partition suit.
Huh? Partition suit.
I tell you, Lordship, what has happened. I am one of the defendants.
Are you a co-sharer?
Definitely, yes. Now,
other side, all the defendants are
now I'm the
parties
major-
to the.
Yes. Now, Milord, other brothers and sisters, they are also parties to the suit. One of the Milord third party, Chandan Dash, he has filed, Milord, the partition suit. Who is Chandan Dash? Chandan Dash is a stranger purchaser. Now, Milord, what happened? Except one sister, other brothers and sisters have sold their share to my client.
Oh, preemption.
Exactly. One of the sister has sold this to Chandan Das.
Yes, preemption.
Chandan Das is a third party. Milord, Lordship knows either 44 of the Transfer of Property Act, they can't get joint possession unless they pray for partition. Now, Milord, they have prayed for partition. In that case, Milord, partition suit, I filed an application under section 4. Preemption, I want to buy back your share because ultimately this is a dwelling house.
No, preemption is there. Partition in
Exactly.
partition
That
right
has
of
been
preemption is
rejected on the ground that this is not the appropriate time to file.
When is the appropriate
The court has not said so. Evident trial is required. I am armed with the division bench judgment of your Lordship's court.
What?
Following contestor course, Milord, that original judgment, there is no time. Only, Milord, one.
No, proposition. What is the proposition, division bench? No, tell me.
The word sue for partition does not mean for partition, filing a suit for partition. Moment a stranger purchaser by his conduct or otherwise prays for a decree of partition.
Correct. First, the court's duty is to see whether preemption has been exercised or not.
The next paragraph, there is no time to exercise that right.
No.
That is exactly the impugned order.
No.
That is exactly the impugned order.
Preemption is a right.
I can exercise at any point of time. But I'm praying for stay of the partition suit, Milord, filed by the third party. This can't go on. Milord, this is a Milord.
Wait.
In any way, they have not taken possession.
Let me see then. Ashun. Mr. Shaunak Bhattacharya, Learned Counsel, appears for the petitioner being defendant number
1
in the pending partition suit. Paragraph. The fact of the original petition shows that no notice of caveat, no notice regarding lodging of any caveat had been received. No, but the department's noting, no caveat. ঠিক আছে. By the department as on September 11, 2025. Full stop. Petitioner submits that the partition suit has been filed by the alleged purchaser
Third party purchaser. Stranger.
in respect of a share of one of the co-sharers without co-sharers, full stop. Application, show me. Section 4.
Yes. Kindly see, my lord.
Parties have filed written statement.
Yes, page 26, defendant number 1. Others are not interested. I have
The
purchased.
petitioner being the first defendant in the paragraph. First defendant in the partition suit has filed its written statement. Show me.
35. Relevant pleadings, my lord, page 38, para 11, 12, 13.
Paragraph. The petitioner
Page 38, para 11, 12, 13. 14.
in July 2023 took out an application.
June, June. 4th June 2024.
24th June.
No, your application says
yes, June.
25th July 2023.
Whatever. That is the only
Somendra Nath.
Shubhendunath.
Kindly come to page 40.
25th July. Kindly see the stamp of the court at the top, Miller, 24th June.
So how it could be in July?
Oh, no, correct. This is 25th July 2023. Yes. My lord is.
On hobe dibe, in na, on July. Took out an application plaintiff, co-sharer did not, purchaser did not file the petition suit.
Yes, partition suit, Chandanda.
Now kindly come to page 40. Read your prayer.
It is most humbly graciously pleased regard to the valuation of share.
The seller's share. Seller's share. Who is the co-sharer? ठीक, की बोलना? So I did. What is the impugned order? Show me.
Yes. Kindly see.
And took out an application on such and such in the partition suit as a co-sharer of the property for exercising his right of preemption under Section 4 of the Partition Act.
12th August, last 3 pages of your lordship brief. Kindly see, my lord, the relevant portion, which is the second page of the impugned order, the last paragraph. Peruse the petition. Kindly see the second page. Earlier facts are kindly at the bottom. Peruse the petition and other materials on record and heard the submission of learned advocate of both the sides, and after hearing both the sides, it appears to me that defendant number 1 has filed the instant petition under Section 4 of Partition Act.
Partition Act, 1893.
claiming that the plaintiff is a stranger purchaser of the undivided dwelling suite, the suit property, and the defendant number one, being the co-owner of the suit property, intends to purchase the share from the transferee of the stranger purchaser and prays for valuation of the share. On the other hand, the plaintiff has categorically rejected the claim of the defendant number one that the suit property is unpartitioned dwelling house of the defendant number 1, 2, 3, and the pro forma defendant number 4. This court view that at this pre-trial stage, without adducing any evidence, it cannot be ascertained whether the suit property is a partitioned property or unpartitioned property. When whether the stranger purchaser purchaser of the unpartitioned property suit property. Considered the above fact, I am of the opinion application filed by the defendant number 1 under section 4 of the Partition Act 1893 cannot be considered at this pre-trial stage, and the same is rejected as premature. Completely erroneous finding. Had it been a partition suit, what was the necessity, partition property, what was the necessity of Chandan Das to file the partition suit? And that's why that's why Millard, that judgment Millard cites says, Millard, there is no stage.
Mr. Bhattacharya, you have been given liberty to file, correct? So, why don't you file it at the appropriate stage? Wait. At the appropriate stage. And I will direct that if such an application is filed, the same should be decided first before proceeding for passing final decree. The preliminary decree.
Millard, according to me, in view of this judgment, this is the appropriate stage. This is the appropriate stage. Had it been a Millard partitioned property, divided property, there was no requirement of filing Millard the partition suit. Therefore, the plaintiff by conduct admits that this is an unpartitioned property. Dwelling house.
Yes.
Therefore, this is the approach. Why should I unnecessarily, subject to correction by your lordship, face trial? Others, brothers and sisters have sold it to me. I am the majority shareholder. Only one of the Millard sister has sold it to this plaintiff Chandan Das. I am as of today, I am the majority shareholder of the undwelling, and I am.
All right, I'm staying for the time being. Serve and come back. I have No, what I was thinking, two-way. I was thinking that since you have a liberty to apply, you will apply at the appropriate stage, and before deciding your application, preliminary decree shall not be passed.
Millard, this is it can be decided now.
Now, what you are saying, it can be decided at this stage. If that is so, then this order is wrong. Then this order will be set aside. Exactly. So for that, I want to hear the other side.
I'll serve notice.
Otherwise, I would have directed that and dispose of your application. কি বললাম? একদম মাথার উপর লিখুন, this is an assigned application filed under Article 227 of the Constitution of India. তারপরে যা বলেছে এখন দিয়ে এবার লাস্টে আসুন কি বললেন। আচ্ছা, প্যারাগ্রাফ। The order impugned dated August 12, 2025 filed by the civil court, passed by the civil court shows
Senior division.
that the application of the petitioner has been rejected as premature and liberty has been granted to the petitioner to file the similar application at the appropriate stage. Paragraph. being agreed by the said impugned order, the instant application has been filed and the petitioner contends that when the said application has been filed, it was the appropriate stage. As the partition would not have been filed otherwise, unless the plaintiff claims partition of it, partition of the suit property. Full stop. This clearly shows that the suit property being a joint property, suit property being still a joint property, joint undivided property, the partition suit has been filed. Full stop. Paragraph. This court finds a prima facie case. Full stop. To file an application claiming preemption is the right of a co-sharer. Full stop. But whether the stage at present is appropriate or not, for deciding the same, the presence of the plaintiff, the presence of the opposite parties are required before this court. Full stop. In the meantime, if the partition suit proceeds, the valuable statutory right of the petitioner who has applied claiming right of preemption may be prejudiced. First paragraph. Accordingly, there shall be a stay of further proceeding in the pending partition suit. Until further order. Full stop. Paragraph. The petitioner shall serve a copy of the application along with a copy of today's order upon the opposite parties and file an affidavit of service when the matter shall be taken up next.
Plenty.
Why the other defendants?
On my side, kindly see me not the cost title. Kindly see me not the cost title. They are on
Very well, opposite party.
opposite party. Because Orchona, Oruna, they have sold it to me. Only one daughter, Oporna, he has sold it to Chandan.
Full stop. You have disclosed all the sale documents in your favor in this revisional application?
I've disclosed the written statement, my lord. There, my lord, all the
whatever. So
yes,
this application contains those.
Contents.
কি বললাম?
দেখতে চাইবে যেরকম
Urgent আছে. Stay below. Paragraph. The matter shall appear under the heading motion within bracket assigned on February 27, 2025. 26. February 27, 2026. এটা ফেরত দিয়ে দিন তো।
Sorry, my lord, there is no chance in January.
Next.
My lord, here, my lord, for the petitioner, this is also assigned to your lord.
Yes.
I am the preemptee.
Preemptee.
Yes, in an application under section 8 of the Land Reforms Act seeking preemption. Initially,
under section 8
of the West
Land
Bengal
Reforms
Land Reforms Act preemption. Now, my lord, what happened? The preemptor filed the application for preemption on the ground of co-sharership. Now, what happened? Initially, that application was filed in a wrong court. Court suo motu takes it up and says, I do not have territorial jurisdiction over the matter. Under Order 7, Rule 10, the application is returned to the plaintiff with liberty to file before appropriate court. Now, my lord, exercising this liberty after a long gap, my lord, in appropriate court, my lord, the application was filed. There,
you want an early disposal?
No, I'm the preempt.
Oh, preempt.
I took point of maintainability. Why? First, in your application, you have not specifically pleaded or claimed benefit of Section 14 because he was perusing on the last occasion in a wrong, correct remedy before a wrong forum, not a wrong remedy before a wrong forum. He filed preemption, but in a wrong court. He did not say about a single word about the pendency of that earlier and giving leave by the earlier court in the subsequent preemption in that returned application.
It's a mixed question of law and fact.
Now, my lord, in the meantime, on the face of it, my lord, 1 year has passed. Now, my lord, now division bench, special bench judgment has come. Now, my lord, preemption, my lord, from the date of registration, it has to be filed within 1 year from the
date of
registration. That is gone. One. Number two, my lord, I'm with those line of judgments.
No, but it's a mixed question of law and fact.
I'm on the other point also. I'm on the other point.
I can at best direct the court to dispose of the application.
Rejected. Maintainability application rejected.
Right. Maintainability points shall be taken at the time of hearing of Section 8 application.
No, maintainability was decided in my favor. The second preemption application was dismissed. Challenging that preemptor preferred an appeal. Appeal court allowed and restored the preemption application. Challenging the appeal court's order, I am before you.
So I will be saying that the point of maintainability as raised by your client shall be decided.
On the face of it, it goes.
No.
On the face of it,
no. It's a mixed question of law and fact.
Face of it, I can show here and now. I will show it to your lordship. On the face of it, it goes.
Very well, you serve and come back. Go in interim order.
No, not required. Preliminary standard.
But pendency of this application shall not preclude them to proceed. In the event they will proceed, they shall consider your maintainability point first. No. Or I can dispose it of simply by directing that since the preemption application has been revived, you are there as a party to argue. You shall, whatever points you will be taking, point of maintainability, that will be decided first.
Trial court has no scope to decide that.
Huh?
Because appeal court had reversed it. Trial court, unless your lordship set aside the order of the appellate court, trial court has no jurisdiction to decide that.
Let me see the order of trial
authority
court.
has Milord higher.
Let me see the order of trial court.
Appeal court.
Appeal court.
Very well. Kindly, certified copy, Milord.
Yes, I got it.
Yes. Kindly see, Milord, the points for decision. The lordship would kind enough to come to page 4 of the impugned order. Page 4. When a plaint or preemption application is returned.
Oh, acha. Appeal court held it is within limitation.
Within limitation.
Then it has to be hard. Ashu.
And Milord, that and my second point would be that in the second to claim section benefit of Section 14, you have to plead it. I'm with those line of judgments.
Equally, Section 3, if empowers the court to look at it by itself and reject the claim, if it is barred by benefit, court also may look at it. Very well, very well. We will see.
Here, that situation is over. Section 3 has been exercised here.
Ashu. The petitioner is a preemptee. Listen. The petitioner is a preemptee under the proceeding, in the proceeding filed by the preemptor under Section 8 of the Land Reforms Act. The principal plea of the petitioner is that the application filed by the preemptor is barred by the law of limitation, is barred by law of limitation. Full stop. The issue had traveled up to the civil appellate court. When the civil appellate court decided that the preemption application was filed within the period of limitation, now issue had traveled there aage likhun. The jurisdictional authority on the ground of limitation has rejected the preemption application. Full stop. The point of limitation was taken by the petitioner herein, being the preemptee. Paragraph. Being aggrieved thereby, an appeal was carried out before the civil appellate forum. When the civil appellate forum reversed the order of the authority and restored the preemption application to its file, holding that the application was not barred by the law, barred by law of limitation, right? Full stop.
Yes.
Challenging the said impugned appellate order dated May 7, 2025. The instant application has been filed under Article 227 of the Constitution of India. Full stop. আচ্ছা একদম মাথার উপর, this is an assigned application under Article 227 of the Constitution of India. হলো এবার নিচে
7th May 2024. 7th May 2024.
The fiat on the application shows that the department has endorsed that no caveat was lodged as on September 18, 2025. Paragraph. To test the legality of the impugned appellate order, presence of the opposite party, single.
Opposite party, yes.
Presence of the opposite party.
Or opposite party.
Presence na. An opportunity shall be given. An opportunity of hearing shall be given to the preemptor opposite parties.
Party.
Preemptor.
Preemptor opposite party. Somnath Adok.
And the pro forma opposite party. You have met pro forma?
Yes, sold. Yes, sold.
All right. Take a An opportunity of hearing should be given to the opposite parties. Paragraph. Accordingly, notice. Accordingly, the petitioner is directed. Accordingly, the petitioner is directed to serve a copy of this application along with today's order upon the opposite parties, and to file affidavit of service when the matter shall be taken up next. Paragraph. It is made clear that today the prayer for interim relief has not been considered. Has not been considered. And depending upon the circumstance, the petitioner shall be at liberty to renew its prayer for interim relief.
Kindly take this up on January. Kindly takes this up on January.
Huh?
Kindly takes this up on January. Kindly takes this up on January. Otherwise,
I have to give preference to my regular determination, Mr. Bhattacharya.
Judgments only 15 minutes.
All right. Same day. The matter shall appear under the heading.
Kindly stage the operation of the appeal court's order.
Motion assigned. I made it clear that depending upon the circumstance, you will be at liberty to renew your prayer, renew your interim prayer. That I mentioned. কি বললাম? হ্যাঁ, the matter shall appear. হ্যাঁ, পড়ুন। To renew its prayer for interim relief. Full stop. Interim relief, comma, at the appropriate stage. তারপর কি বললাম? Motion bracket assigned ওই same date. হ্যাঁ, 2020. Thank you.
Well, 30 minutes I am for the petitioner. But I have
What is the matter, madam?
that is the education matter for approval of the DA getting school, madam. DA getting school, they are seeking for approval only to get the DA. They are fighting. Two petitioners is here.
Stop and come back. There is no scope for any interim order.
Yes, I know, but they are fighting since 2008. One after another, but DI is adamant. That's why it was sent to the principal secretary. Principal secretary did not consider at all.
Considering the averments in the writ petition and considering the submissions made by MS Shanti Das, learned advocate appearing for the petitioner, comma, this court is of the view that there is no scope for any interim order. Poster. Paragraph, none appears for the respondents, nor any accommodation has been sought for.
Notice. I have already served the notice.
Affidavit of service.
Yes, this is also.
মাথার উপর লিখুন affidavit of service filed in court
There
today.
after matter was assigned, so that's why.
ঠিক আছে, affidavit of service along with the notice.
Yes.
Further notice.
Yes.
Filed in court today is taken on record. চলো, কি বললাম? A paragraph affidavits are called for. পড়েছেন? Affidavit in opposition shall be filed on or before December 22, 2025. Affidavit in reply, if any, thereto shall be filed by
within a week, Lord. Because battery is pending since
January
long,
20, 2025. I will not be able to take up, madam. The matter shall appear under the heading hearing assigned on February 20, 2025, 2026. I have to give preference to my present determination.
I appreciate, but kindly consider.
These are all assigned matters. I cannot help.
We are fighting since 2008.
I understand. I feel the pain, but I cannot help. Yes, next.
Lordship can do. That's why we have come before Lordship.
Next.
My lord, I am for the petitioner, my lord.
You're for the
petitioner, my lord. This matter, my lord.
Affidavit?
No, my lord. My lord, the division bench already held, my lord, in this matter, my lord, that respondent authorities are directed to release the retrial dues along with 9% interest. My lord, respondent authority has already make payment only of the retrial dues, no interest.
The principal amount.
Only the principal.
But not the interest.
My lord, kindly turns to.
So serve and come back. Serve and come back. Ashun. Considering the issue involved in this writ petition and considering the submissions made by Mr. Shunit Kumar Rai, learned counsel appearing for the petitioner, comma, there is no scope for any interim order. Paragraph. Petitioner shall serve a further notice along with a copy of writ petition and a copy of today's order at the office of the learned government pleader.
My lord, I have already served. Only notice is required.
Where is your affidavit service?
My lord, last occasion I have filed probably, my lord.
Huh? Fine. দেখছি না তো।
Not my lord, I have served.
No, I don't disagree. I don't disagree. You're there still in the panel? Come on.
My lord, I am praying for not today.
You are appearing for?
The petitioner.
ওটা বলেনি।
ওটা বলেনি।
কি বুঝতে পারলাম?
He is appearing in 32.
Oh. না এটা কেটে দিন। None appears for the state despite notice. Paragraph, in view of the above, Mr. Gaurav Das, Learned State Counsel, who is present in court, is requested to appear, hold the brief for the state to assist this court henceforth in the matter. His appearance shall be regularized by the office of the learned government pleader forthwith. Paragraph. The petitioner, advocate on record for the petitioner, shall serve a copy of the writ petition along with a copy of today's order upon Mr. Gaurav Das, learned advocate forthwith. Paragraph. He shall take instruction in the matter and apprise this court on the next day with the supporting records. Paragraph. The writ petition shall appear under the heading motion assigned on January 30, 2025. Yeah, 6. Thank you.
I see.
I'm for the secondary board. I'm for the.
Lord, I am for the. I am for the school authority in this matter.
Take the microphone.
I'm for the secondary board, lordship. My lord, I am for the petition. I am praying for not today. I am late by Fidosh Shamim and he is busy in another court. So I don't have any clear instruction. I don't have any instruction at all to.
Then come in the month of February. Ashut. On the prayer of MS
Rajashri Shah. Rajashri Shah.
Rajashri Shah, London advocate appearing for the petitioner. The writ petition shall appear under the heading motion assigned on January 30, 2025. 26. Paragraph. Mr. Shunit Kumar Rai, Learned Counsel, appears for respondent numbers
9, my lord.
9. MS
Shashwati Chatterjee, lordship.
Shashwati Chatterjee, Learned Advocate, appears for respondent number
Respondent number 6, lordship. 5 and 6.
5 and 6. Sure. Next.
Lordship, I am for the petitioner. Lordship.
Lord, I am for the state. Lordship, this matter relates to HRA, your lordship. This is an assigned matter. This matter relates to HRA, your lordship. This is evidence of service. And your lordship, this similar order has been passed by your lordship. This is the order.
So who is the authority to consider?
Lordship, in this matter, everything is kind of only the WPN number to be changed. Otherwise, your lordship kindly consider this order passed by your lordship.
Show it to him. Same memo.
Yes, your lordship.
Memos are all same. Show it to him.
স্কুলের নামটাও কিছু নেই এই যে WPN.
But appeal is still pending and your lordship.
Appeal is still pending. Oh, subject to result of that appeal. Yes, yes.
So lordship can.
Yes, yes. ঠিক আছে, তো give the corrected copy, give the here and now correct it and give it to him. আচ্ছা, appearance এ লিখে দিন মিস্টার শুভ্রজ্যোতি ঘোষ, learned advocate for the petitioner, Mr. Gaurav Das, learned counsel for the state, learned advocate for the state. তারপর affidavit of service filing court today is taken on record. Correct it.
Next two matters are also same for this.
Are first one by one. So disposed of. Correct it. Correct it. Give your names, both the names. Write down. You are there in the next two matters.
No matter, I am in the next matter. I am happy.
Correct it. Give his name, your name. Corrected. Change the name. Why don't you bring it?
Actually, it's my fault.
Yes, next matter.
I
Mr. Pinaki Dole for the state.
am for the school respondent. Lord.
Mr.
Shantanu Talukdar.
Shantanu
Talukdar.
Talukdar, learned advocate for respondent number
5 and 6.
5 and 6, oblique school / school. আমার দেখিয়ে লাভ নেই, ওরা দিচ্ছে দিয়ে দিক, কারেক্ট করে দেবে, তারপর একটা একটা করে রাখুন, ওটা আগের ম্যাটারে ঢোকান। গেঁথে গেঁথে গেঁথে, না তো দিদিরা বুঝতে পারবে না।
নামও তো চেঞ্জ করতে হবে, চেঞ্জ দ্য নেমস অলসো।
One by one. 34. Give me the order. 34.
The name has to be changed. Cost has to.
ওটা 34 এ রাখুন। নেক্সট,
I'm for respondent number 5 and 6 Milord school.
মিস্টার
Shantanu Talukdar.
হ্যাঁ,
Shantanu Talukdar.
শান্তনু তালুকদার for respondent number 5 and 6 stroke school. Mr. তন্ময় কুমার ঘোষ, learned advocate, appears for the state.
একটু নামটা লিখে এখানে লিখে দিন। কোথায় লিখবো? হ্যাঁ, কেটে ওটা লিখে দিন।
হয়েছে?
Number 35 plots. Item 35. WB number কত ছিল আগে?
কারেক্ট করে দিচ্ছি ডাব্লিউ নাম্বারটা কত ছিল
15524 15524
524 তারপর 25 ঠিক আছে হ্যাঁ চলো অরিজিনাল সাইড ডাকো
এটা নিন
My lord, may I permit to mention one matter in the today's item number 26, my lord.
কিসের
Appellate side, my lord.
সরি নেক্সট অরিজিনাল সাইড ডাকো ওই একজন মেনশন করবেন বলেছিলেন কোথায় গেল ইয়েস এটা I make it very clear that appellate side matter will be taken up on Friday. First the content, then I shall follow according to the list. But to be very candid, since my principal jurisdiction is the commercial court, I will give preference to that. So the hearing matters, perhaps I will not be able to reach
I know
in the appellate side. Next.
Hearing matters will be taken up on the Friday also.
List will be there, but I do not know when I will be able to take out. Yes. Acha, yes.
There is some assigned contempt also before your lordship.
In original side. Yes, assigned content I have taken up. I have taken up those hearings are not taken up.
Not hearing, my lord, it was an item number 39.
Dekhi.
That is, and 39 তো original side নয়, appellate side বলছি।
দাও লিস্টে এক্ষুনি দিলাম তো এই তো দাও $39, yes, contempt assigned. All right, next day. I do not know, it is over. So what has happened, I don't know. You have not come, matter ends. Chalo, next.
I mentioned this matter for extension of the interim order.
Serial number, madam?
39, your lordship, of today's list.
At order koro 39 39 huh? MS?
It's a CS.Com 82 of
MS?
Manisha Das, your lordship.
Manisha Das, learned advocate, appearing for the plaintiff,
Your lordship.
has mentioned this matter. Full stop. Since the interim order passed last extended on August 21, interim order last extended on August 21, 2025.
On 30th September, your lordship. 30th September, your lordship.
Where is that order?
Your lordship, it is annexed with the mentioning slip only.
Since the extension, কি বললাম? September 10, 2025 expires today, comma. The same has been taken up upon mentioning out of turn upon mentioning, and the interim order stands further extended till January 30, 2026 or until further order, whichever is earlier.
Grateful.
And then লিখে দিন যে none appears for the respondents.
Number 1.
Chalo, pastor.
It's in the suit where the defendant had taken up the section 8 application which your lordship had considered and reserved for judgment. But on the other day.
In view of the pendency of the judgment, section 8.
Section 8 was GA4, which your lordship has already heard.
Right, so nothing, let's not.
GA5 is for production of the arbitration agreement. So this will be subject to your lordship allowing the section 8. So this can.
All right, forget it. Adjourn. Next.
For this application, there's the application for extension of time to file the written statement.
Your
There's
lordship.
the direction upon the master to file a report.
When you have taken the application, on which day?
Your lordship, it's my application. Your lordship, I have taken it out on 3rd April 2025. Your lordship, which is within the 120-day period. Your lordship.
120-day
period. Your lordship.
120th day.
No, your lordship. It was on the 88th or 89th day.
Achha.
Your lordship, I had taken leave of this honorable court to file my written statement, and on that same day, 3rd April, your lordship, 3rd April, I took my leave to file the written statement, which was allowed subject to acceptance of the written statement by this honorable court.
No. 3rd April, you have filed your written statement with leave.
Yes, your lordship.
To the department.
Yes, your lordship.
And the 3rd April master summons has been taken up.
Yes, your lordship. I filed my application for acceptance of the written statement on 3rd April itself.
On 4th April.
I stand corrected, your lordship.
So when the written statement has been submitted?
On 3rd, your lordship.
Couldn't have been without the master summons. The leave couldn't have been granted. That's why, my lord, there's an order.
No, Mr. Ghosh. One matter is being argued by Mr. Pranit Bagh, where may not be disclosed proximity, but the issue is written statement submitted with the leave when the application was not on board.
Lord, beyond the 30-day period,
application was not on the board during 120th day application, but the written statement was accepted by the leave. Right. Reading of Order 8 amended. I asked Mr. Bagh to satisfy me whether, suppose leave is granted to submit the written statement today, but application is not on the board on today. Maybe it is well within. Let's say it is within 40 days. Then also, whether the leave can be granted without the application being on board. 120th day is the right.
Yes.
I don't mind for that.
No, my lord. 120th day is not a right.
Not extension. To pay for an extension.
Yes.
To pay for an extension up to 120th day, the right is there. Consideration by the court. Subject to consideration by the court. But whether without filing an application, can you obtain a leave?
Lord, if left to my understanding, and my lord, your lordship has seen this, my lord, since I don't know wherever your lordship has joined the profession, well, the applications can be moved on the original side orally. I'm always on it.
No. Then let's see. That is his submission. I will have to deal with it. Because satisfaction of mind has to be.
Yes, no, otherwise, my lord, after the Commercial Codes Act, because the original side rules, now it's become different.
It's a special statute.
It's a special statute. That's why that application has to come.
Right. Chalo, seta pore dekchi.
Yes.
Do one thing. Don't do it today.
Yes.
Okay. Your lordship, I would just like to point out, I have my digital copy here. In my application, my advocate on record has endorsed that it was submitted on 3rd itself at 3:25 p.m. Your lordship.
Madam, don't move it now. Wait for some time. Let me hear that proceeding in detail, because lot will depend on the fate of that. Right, Mr. Ghosh? So lot will depend on the fate of that. The moment you have taken out your application, your limitation starts, it stops. So whether ultimately on the principle of law it will be allowed or not, if it is allowed, then your will also be allowed. Subject to then going by your explanation. That's a different issue. Their court can be little liberal, no issues. But on the rigor of law,
For the benefit of everybody, I would say Lordship will be kindly be liberal.
no, of course, but on the rigor of law, no equity plays. No
Because it's
equity
a special
plays.
statute. Otherwise, if your Lordship had everything.
Explanation, এক কাজ করো এটা না ঠিক আছে এখন ফালতু অর্ডার করে লাভ নেই থাকুক ওই ওই মামলাটা কবে আসছে প্রণীত বাগেরটা মনে সম্ভব না মনে রাখা সম্ভব না
Well, we'll keep a watch in case it's taken up.
You better ask Mr. Pranit
I will
Bas
ask Mr. Bas. I'll do
when it is fixed.
I'll do that. Grateful.
Item number 4.
The respondent in the two applications. Both. Both. There is no petition.
To dismiss for default.
Our restoration লাগাবে
আমার ফি হবে
না কিছু হবে না কিছু হবে না বলো
Would it be Lordship's pleasure then to fix a time for this matter? That they will be compelled.
I will first whether it is permitted asked from anywhere else then
permitted যাই না টেবিলের ব্যাপার না
go and ask. I will inform.
বলিস না ও রে বাবা 2 সপ্তাহ নেই কি আনন্দ নাম্বার শুড fix up whatever
pass to
let it remain in the list as it is হ্যাঁ ঠিক আছে বেশ থাকবে pass to
Number 6. My application under Order 8 Rule 1. Application under Order 8 Rule 1, Your Lordship, are being led by Mr. Singh.
No, other side kotha.
Thakkar is there. A very short point involved. I am, Your Lordship, the defendant. Now,
Where is the other side? Passed over.
Written statement we have already filed. Now the only question requires whether my written statement will be accepted or not. In the service report, there are 2 dates mentioned. One, Your Lordship, by way of belief when he has actually delivered.
When the master summons taken out. Prior to the date of filing of written statement
Written
or
statement
after?
filed within 119th day.
And the master summons?
Lordship, master summons taken thereafter.
After 120.
Before that. 1 day before that. Before 120th day. That is, I am not on that, Your Lordship. We are on, Your Lordship, kindly see once my application.
So let the other side come. Chalo, next passed over.
7 I appear for the plaintiff. The other side isn't appearing, it seems. Lord, I appear for the plaintiff, my lord. We're enjoying an interim order. My lord was pleased to extend the interim order earlier this week, my lord. Lord, the matter is remaining in the list. It's an adjourned motion. There are 2 applications, one under Section 8 filed by the defendant number 1, and my lord, my main injunction application, which
So
is
Section 8 has to be heard
yes,
first.
my lord has directed that as well.
Sure. Next.
Item number 8.
Sure.
For the plaintiff for opposing this application.
8.
The microphone.
I'm opposing this application, I appear for the plaintiff.
Lord, this
Be
is,
louder.
my lord, this is my application, my lord.
Yes, Lordship. I am online.
Yes.
I'm sorry. My lord, possibly Mr. Gupta is appearing for the defendant,
Defendant number 2.
in item 7, which has been passed over. My lord, it's been passed over, Mr. Gupta. Item 7 has been passed over.
Okay.
Yes. You are for?
I am for the defendant, my lord. Defendant, I have applied under Section 8. In item 8. Yes. Section 8 application, my lord. Lord, it's a simple case. Here, I'll be very quick, my lord. I won't take much time. This is coming up after affidavits. It's an adjourned motion. I'll just quickly indicate.
So it's a then chamber application for final
disposal.
Very well.
Mine.
Hey, affidavit gulo dao. Show me the
Yes.
contract on which
Yes, my lord.
they are insisting
My lord, may I just
that contains an arbitration
yes,
clause.
my lord, just a 2-minute background, just 2 minutes. I will not take much time as to what this suit is about. My lord, I am
the suit for?
Yes, it is a suit, my lord, for declaration and money. Really, I am the lender, my lord, for money, essentially for a refund of interest. I'll indicate. May I give, my lord, the factual background once, my lord? My lord, the plane starts. If my lord wants to see the
38,
plane, page 38, page 41. Really, my lord, the pleadings start. My lord will kindly see the reliefs that are claimed at page 59. My lord, it's money. I'm sorry, no declaration. It's only money. But they've made pleadings as to, my lord, wrongful charging of interest by my client. My lord, I'm the lender. May I just give, my lord, the factual background very quickly?
It's an agreed rate of interest.
It's a, my lord, this is a I am a finance company, my lord. I was the lender. My learned friend's client is a borrower. It's a floating rate of interest. It's a floating rate of interest.
It's agreed. The
It's agreed.
modality is
Absolutely,
agreed.
absolutely. No dispute in that regard.
Acha.
Most surprisingly, my lord, the entire interest as well as the principal is serviced. No due certificate issued.
But
Loan
then they say that I have paid excess interest, which is beyond the contract. So return it. That's the case. Fair enough. Show me that
Loan
arbitration
agreement
is there.
Yes, my lord. The loan agreement starts from page 9.
Show me the arbitration clause.
Yes, my lord, directly, my lord. My lord, 27, my lord, will kindly come to. My lord, clause 22 at page 27.
You are resisting the plaint on arbitration clause.
Yes, my lord. My lord, 27, and thereafter, my lord, one more.
Can you show me, sir?
Yeah, I'm sorry, my lord. I'll please, my lord. My lord, may I?
22, a clause
Page 27, clause 22. My lord, may I just place very quickly? This loan document shall be governed by Indian laws and the courts as mentioned in Schedule 1. Well, this is also important because I also taken a point of territorial jurisdiction. I'll come to that. Hereunder shall have exclusive jurisdiction relating to any matter so issue under or pursuant to the loan documents, notwithstanding anything to the contrary. My lord, A. If any dispute, disagreement, difference arise between the parties, my lord, includes obligers during the subsistence of the loan agreement and or thereafter. My lord, will kindly note and or thereafter. In connection therewith, inter alia, the validity, interpretation, implementation, alleged breach of any provision of the loan, the loan documents, jurisdiction or existence, appointment of the arbitrator or any nature whatsoever, then the dispute shall be referred to a sole arbitrator who shall be appointed by the lender. The mechanism for appointment is invalid, my lord, but the intention to arbitrate is there. Thereafter,
mechanism is not required.
Not required. In a Section 8 proceeding, all I have to show is the intention to arbitrate.
The averment of the plaint.
Absolutely, my lord. Absolutely. Now, this is the arbitration clause, my lord. As to territorial jurisdiction, it's my obligation, my lord, to kindly take, my lord, to the schedule of the loan agreement. Page 29, it starts.
Wait, sir.
I'm sorry.
Yes.
Page 29, if my lord has once. This is the schedule. My lord, I'll skip over to only the relevant portion. I will not take much time. Page 32, if my lord.
You proceed in your own way. Not to worry.
I'm sorry.
Just proceed in your own way. Feel comfortable and proceed.
Yes, my lord, page 32, if my lord has.
Page
32. That's a part of the schedule to the loan agreement.
Exclusive jurisdiction.
Exclusive jurisdiction, New Delhi.
Of arbitration.
My lord. Both New Delhi. Now, my lord, one of the conditions, I'll complete the documents and thereafter, my lord, my submission I'll make. My lord, we kindly come to the plaint now. My endeavor will be to show that the cause of action as pleaded in the plaint.
Admittedly, wait. This is the agreement under which loan was granted. Correct? Under this agreement, you have paid. I mean, the plaintiff has paid.
My lord.
The borrower has paid.
My lord.
Right? Correct?
Now, page 41.
Show me the first averment from the plaint.
Yes.
That he has averred this agreement.
Yes, my lord. Page 43, my lord, will find that. Page 43, para 6 of the plaint. Page 43, paragraph 6. My lord has that. May I please?
Hmm.
Well, The defendant by a letter of sanction dated 28th February 2018 and copy whereof is annexed hereto and marked with the letter blank, with the letter A, have inter alia granted sanction of a loan to the tune of
This
30.
was the agreement
This was
dated
the
28th
28th
February.
February 2018.
You have shown to me.
Yes, my lord.
Fair.
My lord, that was page 9.
All right, all right, all
Yes,
right. Then proceed.
Yes, my lord. My lord, then 43, my lord, has seen the averment.
Wait.
I'm sorry. Page 43, may I please, my lord? The defendant by a letter of sanction dated 28th February 2018, a copy whereof is annexed so and so, inter alia granted sanction of the loan to the tune of...
Wait, sir, wait.
I'm sorry.
Page 43, what you are showing?
Paragraph 6, my lord. This is a part of the
yes,
plain.
I've read that.
My lord. My lord, then I'm not placing it separately, my lord.
I've read that.
Yes.
Even paragraph 10 also I've read.
Yes, my lord. Their entire cause of action is premised on the agreement. Disputes arising out of the agreement. My lord, will directly come to page 57 now.
Wait. Yes, sir. Tell me.
My lord, I'm assuming my lord has gone through the plaint once, my lord. So, my lord, I'll just...
No, you place in your own way.
Yes, my lord.
You don't require to place specific paragraphs, just refer to those.
I'll make my submission, my lord. Yes. My lord, will kindly note that the plaint proceeds completely on the basis of the loan agreement. There is no dispute as to execution of the loan agreement. No allegation. I'm sorry. My lord, there is no dispute as to the loan agreement being executed by the plaintiff. There is no dispute as to the loan agreement being vitiated by fraud or any of those maladies, my lord. It directly relates to the loan. it falls squarely within the ambit of the arbitration clause, especially even after closure of the loan, because the arbitration clause contemplates that even disputes that have arisen after closing of the loan will be referred to arbitration. There is no dispute in that regard. Only one paragraph I would like to, Malad, may I place for my own satisfaction, Malad?
Yes.
Malad will kindly see their pleading as to the arbitration clause at page 59, at paragraph 52, because the plaintiff is aware that there is an arbitration clause, they make certain pleadings trying to circumvent it.
Show me.
Paragraph 52, if I may very quickly please, my lord.
Paragraph.
52 at page 59.
Correct. Show me.
The plaintiff, there should be an apostrophe as the plaintiff's cause of action in the present suit arises out of the defendant's breach of various Reserve Bank of India guidelines and directions apart from the breach of the provisions of the contract. There is a purported arbitration clause. He notes this, he admits this. In the contract which does not cover the cause of action forming the subject matter of the present suit, the arbitration clause is also null and void. This is on account of the procedure, Muller. It's a unilateral appointment clause. Perhaps that is why they plead this. As per the arbitration clause, the defendant is to appoint an arbitrator who is a persona designate, is the only person who, as per the agreement, would adjudicate the disputes arising out of the contract, being the arbitrator. Such provision is also null and void, being contrary to the provisions of the Arbitration and Conciliation Act 1996, as amended on 23rd October 2015. This is the totality of their case. In the affidavit, my lord, similar allegations are again made as to the arbitration clause. They again say that the plaintiff proceeds on a breach of a statutory obligation on the part of my client. That is why the arbitration clause will not apply. That is the stand taken in the affidavit as well, my lord. I will not place the entire affidavit. I'll leave that to my learned friend. I'll just indicate, my lord. They specify this at page 4 of the affidavit in opposition. My lord, my learned friend will of course apprise my lord of that. Page 4, my lord can have a note. Subparagraph I of the affidavit in opposition. This is their case in the on affidavit as well in the present application. No additional document annexed to this.
Read.
My lord, affidavit in opposition. My lord will kindly take page 4. Subclause I. From a bare and meaningful reading of the plaint, and it would be evident that the plaintiff's cause of action in the present suit inter alia arises out of the defendant's breach of various Reserve Bank of India guidelines and directions. The issue, next J also may I please, the issue as to whether there has been a breach of guidelines of the Reserve Bank of India and the directions passed by the Reserve Bank of India on the part of the defendant is beyond the scope of the purported arbitration agreement as contained in the loan agreement dated so and so. K, if at all disputes which form the subject matter of the present suit are referred to arbitration, the arbitral
This is the
tribunal.
affidavit in opposition filed by the plaintiff. Yes.
There's only two parties. If at all the disputes which form the subject matter of the present suit are referred to arbitration, the arbitral tribunal formed and or constituted in terms of the purported arbitration agreement will not have the jurisdiction or authority to entertain the disputes pertaining to the defendant's breach of the terms of the Reserve Bank of India guidelines and or directions. Now, this is the sum and substance of their defense as to the arbitration clause. Now, a point may be taken because if Muller takes my master summons in this application, I sought for rejection of plaint and dismissal of suit. Those are my prayers. But my lord, in my application, I'll just place that very quickly for my lord's satisfaction. In my
You have not read for reference.
I have not read for reference.
It's a mandate upon the court.
It's a mandate. That's exactly, my lord has taken the words right out of my mouth. That's also the words used by the Supreme Court now. I'll be relying upon that judgment. And my lord will kindly note one more fact. I filed written statement in this reference, or rather in this suit. In the written statement, I've taken the point as to there being an arbitration clause. It is also now settled law that the mere fact that the written statement contains that averment is sufficient compliance of Section 8. Not even a separate application is required. The court on its own motion, so as long as an arbitration clause or an arbitration agreement is brought before
judgment.
Well, I will. Before that, may I please the Supreme Court once, Mulad?
On what proposition?
On Section 8, that it is an obligation of court and
100%.
that and also, Mulad,
It's a mandate.
Absolutely, Mulad.
Not only obligation, it's mandate.
Also, Mulad, their stand, that is, this is a public domain, or rather the subject matter of the suit relates to a violation of statutory guideline. That cannot be referred to arbitration, specifically denuded by the Supreme Court, specifically dealt with. May I just place that? This is 2025, 8 SCC 299.
2025?
8 SCC 299. It is Justice Pardiwala's decision, my lord, or other opinion. My lord, very quickly, I won't place the entire thing.
Wait.
I'm sorry.
आइए तारीख को तो 13 हैं 14 Your name?
My lord, my name. My lord, Shaunak Mukhopadhyay, my lord.
Twenty 8 SCC
299.
Yes.
My lord, here, my lord, I'm relying upon, my lord will kindly take note, I'm relying upon paragraphs 12 to 15, thereafter
Paragraph
12 to 15, and 20 and 21, or rather 20 to 23. 20 to 23.
Yes.
May I directly come to, my lord, paragraph 12 quotes Booz Allen, my lord will directly come to paragraph 14. Paragraph 14, my lord, may I please? That's at page 312 of the SEC report. The assumption, well, para 14, my lord, has the assumption that all matters relating to trademarks are outside the scope of arbitration. This was a suit relating to trademarks, therefore it was contended that that is relating to an erga omnes obligation or a right in rem of a party to the suit.
Assumption that
All matters relating to trademarks are outside the scope of arbitration is plainly erroneous. There may be disputes that may arise from subordinate rights such as licenses granted by the proprietor of a registered trademark. Undisputedly, these disputes, although involving rights to use trademarks, are arbitrable as they relate to rights and obligations inter se the parties to a license agreement.
Basically, a breach of contract.
But this is in the context of a trademark suit, an IP suit. That is why that is the dispute which is arisen before the Supreme Court. That a dispute related.
Where is the relevance in referring this paragraph?
My lord, here because, my lord, it might be contended that is the stand of the plaintiff that like a trademark suit which deals with a right in rem, similarly, perhaps the plaintiff will try to contend the RBI guidelines give them a right in public law or a right in rem perhaps to have the loan dealt with in a particular way. That is the argument that they've tried to make so far as I understand it. I am just relying upon this judgment to show that even when it relates to a right in rem, an arbitration still lies so far as a contractual dispute is concerned.
It's not a right in rem when a breach of agreement is alleged.
No, my lord, here they have alleged breach of an RBI guideline. That is their case.
Suppose
My lord.
RBI guideline.
My lord.
It has a statutory flavor.
My lord.
Correct?
My lord.
Now, if you allege that in course of a transaction out of an agreement, right, the breached party has committed breach of that guideline, will it not be taken in a civil forum?
That is my contention. It should be. It ought to be.
Yes,
this has been clarified by the Supreme Court only to that extent. Now, my lord will kindly now directly. My lord, my point has been made from para 14, para 20 to 23 are most relevant. My lord, may I just place this? The law is well settled that allegations of fraud or criminal wrongdoing. 20 to 23.
Yes, sir. Place it.
Yes, my lord. The law is well settled that allegations of fraud or criminal wrongdoing or of statutory violation, my lord will kindly note, would not detract from the jurisdiction of the arbitral tribunal.
Precisely what I said. It has a statutory flavor.
Absolutely.
If somebody alleges, for that RBI is not required to be a party to that. It's a statutory guideline. If I allege that Mr. Mukhopadhyay, while charging interest, you have violated the norms, it is definitely adjudicable. Adjudication is possible in the private domain.
Absolutely. That is my point. That is precisely my
Next.
point. May I just place this very quickly, my lord? Would not detract from the jurisdiction
You
of the
take your
arbiter.
time, sir. Don't hurry.
I'm sorry.
I'm not in a hurry.
I'm sorry.
Juniors are now fantastic. Juniors are now fantastic.
Idea after 3 o'clock calling matters.
Oh, of course, it's a pleasure, the junior.
Yeah.
And I will hear your junior also.
Very confident.
Absolutely. He's doing a very, very, very big matter before me.
Arguing.
Very good. All the juniors I find very competent now. And I enjoy to interact with them. You know, it's a very lively flavor to interact with the juniors.
We were lucky that Mulot is giving us an opportunity. Mulot. Para 20, Mulot, when I quickly place. I'm sorry, not quickly, I will place. I'll place it, Mulot. The law is well settled that the allegation of fraud or criminal wrongdoing or of statutory violation would not detract from the jurisdiction of the arbitral tribunal to resolve a dispute arising out of a civil or contractual relationship on the basis of the jurisdiction conferred by the arbitration agreement. Once an application in due compliance of Section 8 of the 1996 Act is filed, the approach of the civil court should not be the approach of the civil court should be not to see whether the court has jurisdiction. It should be to see whether its jurisdiction has been ousted. There is a lot of difference between the two approaches. Once it is brought to the notice of the court that its jurisdiction has been taken away in terms of the procedure prescribed under a special statute, the civil court should first see whether there is ouster of jurisdiction in terms or compliance with the procedure under the special statute. The general law should yield to the special law, generalia specialibus non derogant. In such a situation, the approach shall not be to see whether there is still jurisdiction in the civil court under the general law. Such approaches would only delay the resolution of disputes and complete the redressal of grievance, and of course unnecessarily increase the pendency in the court. Once there is an arbitration agreement between the parties, a judicial authority before whom an action is brought covering the subject matter of the arbitration agreement is under a positive obligation to refer parties to arbitration by enforcing the terms of the contract. There is no element of discretion left in the court or judicial authority.
There was one judgment of Justice Ruma Pal immediately after her elevation to Supreme Court. I'm forgetting the name, some South Indian name, much prior to all the subsequent amendments. But on Section 8, when Justice Pal has specifically said it is the mandate on court.
That is, there are judgments which says the court cannot on its own.
Court cannot?
On its own. If you find an arbitration clause.
No. That's a different. But if it finds that it's an arbitration clause, parties apply, then it is mandate.
Then it's a mandate. And if it's covered, then there's no discretion.
Absolutely.
So, yes, there is no element of discretion left. May I just continue, Lord? After placetum F, there is no element of discretion left in the court or judicial authority to obviate the legislative mandate of compelling parties to seek recourse to arbitration. Mullah will kindly note the use of the word compelling parties to seek recourse to arbitration. From my reading, at least, of this and the other judgments of the Honorable Supreme Court, the Section 8 court itself does not appoint the arbitrator. It remits parties to avail of their remedies under the...
It simply refers.
My lord.
It's not an 11 court.
My lord.
It's a referral court.
My lord. So, my lord, there's a positive obligation. That is the sum and substance of this judgment, and also that mere allegation as to statutory violation is not sufficient. It does not denote the jurisdiction of the arbitrator. The arbitrator still resides, or rather has the jurisdiction to even adjudicate if there is a statutory violation. Now, my lord, as to written statement, my lord, that point being sufficient, my lord, we kindly have a look at 2014 SEC Online Delhi.
Wait. 2014?
2014 SEC Online Delhi 4015.
Wait. 2014
SEC Online Delhi 4015.
Do one thing.
My lord.
Come tomorrow.
My lord.
ফেরত দাও, কালকে এটা দিয়ে শুরু করো।
Monday, my lord, I have some difficulty only on Monday. Tuesday, my lord, will keep it kind.
If it's
If it
Tuesday,
comes.
then Wednesday. So then Wednesday.
Monday, I am in some
also
personal
Muskil.
difficulty. I'm sorry, my lord. It's
Eighth
my
Muskil, Baba.
Monday only I have some personal difficulty, my lord.
তাহলে তো কিছু কবে সম্ভব
Let it be on Wednesday, Lordship, we will try.
Mr. Mitro, just to manage the list now, it's
I was the culprit yesterday, so I was feeling so bad yesterday before when I
no,
was
but
doing-
I have. Let me be very candid. No hide and seek in it. I have to be little strict from next week. The juniors are doing very good. They should proceed.
from week after next. Let him do it. Let him do his have his house done from week after next.
The juniors must.
I know.
They will proceed, and if I feel any difficulty, really
That
an
your lordship
assistance
does.
is required,
That your lordship.
then of course I will wait. But if I find my confidence on my pen, may it be wrong, may it be mistake of law, I will proceed. Maybe I will be corrected by elsewhere. But that is I don't mind for. But
If
adjournment.
Lordship goes by junior's competence, then people like me will become briefless altogether because they are very, very competent, all of them. So I mean,
No,
become
juniors
briefless
must.
altogether.
Juniors must. Juniors must. And just don't hesitate whether senior is there or not. He may not be, senior may not be available. Senior may be, yes, Mr. Sen. Senior may not be available to all of you.
He has argued many a matter when I've come at the
Lord, the defendant in my lord the suit, and this is an application for amendment of the plaint.
GA in re GA.
Well, that's GA 1.
IA GA com
1
of
2025.
হ্যাঁ ওটা লিস্টে নেই না তাহলে তো করতে পারবো না
কোনটা GA2 I'm sorry my lord, GA2. GA1 is in my application.
একবার দেখিয়ে নাও তো GA2 টা ঘোষ সাহেবকে ওইটাই কিনা in re IA GA com 2 of 2024.
No, my lord. This is GA2. GA2 is mine. GA1 is the amendment.
GA2 টা আমায় দেখাও না.
It's my application for extension of time to file the written statement.
So that I am not taking.
No, my lord.
GA1.
GA1 is my lord the amendment application in which I want extension.
GA1 টা কি লিস্টে আছে? নেই তো. ঠিক আছে পরের দিন আসুক না.
My lord, before rising, my lord, may I pray?
No mentioning for
No mentioning, my lord. My lord,
GA2,
item number 32.
in fact, GA2 my lord also have to file the reply. I'm sorry. Lordship, pass very well, my lord. Whatever, I leave it to you, lordship.
My lord, item number 32.
I'll come with the reply, my lord.
My lord, item number.
These are not a problem. Extension
my lord,
for affidavit. Come with the affidavit. I will take on record. At best, I will adjourn the matter for considering the other side by the reply. And
yes. We'll serve them an advance copy. And one more thing, my lord, there was a direction, but it's not recorded in the previous order. My learned friend was to serve the type copy of the proposed amendments, which in GA1, which has not come.
I'll serve.
Yes.
My lord, item number 32. My
in
lord,
appellate side list.
appellate
What's
side.
gone?
My lord, my lord,
Sorry.
this is regarding my lord pension matter, my lord.
Sorry,
My lord,
whatever.
came my lord 30 January, my lord.
Sorry.
That petitioner will suffer, my lord.